వచ్చినప్పుడు బ్యాటరీ షీట్ ఒకటి పట్టుకోవచ్చు.
సుభద్ర ఉంది కదండి మా సీనియర్తో ఎవరికి
ప్రాక్టీస్ ఉద్యోగం నేర్పించారు కానీ ఇమీడియట్ గా
కదండి వాళ్ళు అయిన తర్వాత వర్క్ పడుతుంది కదా రాస్తారు ఫుల్ సపోర్ట్ అన్నమాట సార్ నేను వస్తున్నాను అది ప్రయత్నం తీసుకోవాలి
నేను అసలు ఏం చేశానంటే ఉద్దేశం సడన్ గా నాకు కంప్లీట్ అయిన తర్వాత సెంట్రల్ గవర్నమెంట్ ఆర్బీఐ స్టేట్ ఇంకేముంది హైకోర్టులో వస్తాయి రమేష్ చేయడం అనుకుంటాను అతను రావడం చూసి కానీ రమేష్ మీకు హాస్పిటల్ కూడా కదా నాకు చేసేస్తుంది
2009 to 12 బ్యాచ్ సార్ జిఎస్కే అవుట్కమ్ మా గురువు గారు కన్నా సీనియర్ దొండపట్టి దొండపట్టి శ్రీగారు అది 2000 హలో చేసేయండి వెరీ గుడ్
కూర్చున్నామండి మీరు ఎప్పుడు వచ్చారు పండుగ వచ్చారు
అక్కడికి వచ్చారు సెకండ్ ఇయర్ కాలేజ్ ఫస్ట్
कैंडिडेट्स
కాదు బాలు గారు ఆయన తెలియని వాళ్ళు బాగా వస్తున్నారే
కోటేశ్వర గారు బాల కోటేశ్వర గారు
బాలు గారు అంటారు
సార్
సార్ రాత్రి అక్కడికి వచ్చారా వచ్చారా
కింద నంబర్లు ఇచ్చా ఎవరు లేరు అలాగే చేస్తారు
ఎక్స్ట్రా తీసుకున్నాను
చాలా టెన్షన్ చాలా పెద్ద టెన్షన్ ముందు రోజు ఆ రోజు స్కూల్లో సెకండ్ అయితే ఫార్వర్డ్ చేసి లాస్ట్ కానీ సర్టిఫికేట్స్ అలా
అయిపోతుంది
Presentation of rejection failed and discharge of failed.
In the last one, game play. Just see the rest of it. Neighbors to
సింహాచలం ఎంత వస్తుంది శ్రీనివాస్ ఇక్కడికి?
అసలు వచ్చిన తర్వాత 5 రోజులు క్యాంపస్ కూడా దాటాలి.
చాలా మంది కార్యక్రమం ఎక్కువ ఆర్డర్స్ పెట్టుకుంటే ఈజీగా 50-50 అందులో కాకుండా 150-50 ఈజీగా మిగిలిన నాకు నీకు ప్రాక్టీస్
వార్త చేయించదు వాడు దానికి కూడా రాసించింది పిల్లలు అయ్యారంటే ఫస్ట్ 2 rows వదిలేండి సార్ ప్లీజ్ ఫస్ట్ 2 rows వదిలేండి సార్ ఫస్ట్ 2 rows వదిలేసేయండి సార్ ఫస్ట్ 2 rows వదిలేయండి ఏమన్నా అవసరం అన్న ఈ సెషన్ ఉన్నాయి కదా జేసీకా
వారు నేను మమ్మల్ని లేపేస్తారు వచ్చి
అంటే చాలా మంది ఎక్కువ రాదు ఎందుకంటే ఎక్కువ రాదు ఈ 4 రోజులకే వస్తారు $130 కన్నా పెట్టిగా కౌంటర్స్ పెట్టేస్తాం సార్ బేసిక్లీ ఐడి నెంబర్ సర్టిఫికేట్ చేస్తారు
రిజర్వేషన్ ఉన్నాయి
అందుకనే నేను 1K పెట్టేస్తాను
ఫస్ట్ సర్వీస్ స్టేషన్
అంటే ఎక్కడ పెట్టిస్తాను సభవరం దాకా పెట్టిస్తాను. సభవరం వరకు పెట్టిస్తాను బస్సెస్ 1:30 నుంచే పెట్టిస్తాను. ఉన్నాయి. పెట్టాం. సభవరం నుంచి ఒక బస్సు తిరుగుతూనే ఉంది కంటిన్యూస్. అది మెయిన్ ఆర్టీసీ బస్ స్టాండ్ దాకా సభవరం దాకా దగ్గర ఆర్టీసీ బస్ పట్టుకోండి. అదే 10 minutes को బస్సు ఉంది. 10 minutes को బస్సు ఉంది. నేను మన నుంచి ఏర్పాటు చేస్తాను చెప్తాను. క్రెడిట్ కార్డ్ మీద నంబర్ ఆ నంబర్ లిస్ట్ లో మిగిలిన తీసుకెళ్ళిపోతాం. ఎక్కువ పెట్టేసుకున్నాం 150 పెట్టుకున్నారు. చేశారా మాకు ఇన్విటేషన్ చేస్తున్నారు. ఇన్విటేషన్ చేస్తున్నారు.
అమ్మాయి మాటలు
ఈ మధ్యలో తిరిగినట్టున్నాయి. ఒక దాంట్లో మాత్రం కనిపించింది 307 307 కంటే కదా 452 కింద అప్డేట్స్ ఉన్నారు 307 మూడింది చనిపోయిన కిడ్నాప్ చేశారు సొంత మూడు అన్నగారు కిడ్నాప్ చేసి ఆ తొమ్మిది ఆస్తి నా పేరు మీద ఆగిపోతే పేరుకుంటే పెద్దని చూపించింది అంటే 5 గంటలు హెడ్రామా మీడియా వాళ్ళు జపాలు ఆగి డిఎస్పీ పట్ల అసలు అందరూ వచ్చేసరికి 5 గంటలు కంటిన్యూస్ వీడియో ఫుటేజ్ ఉంది అందరూ జాయింట్ కలెక్ట్ ఎవిడెన్స్ చెప్పడానికి వచ్చారు చేశాను బాగా చేశాను అది కూడా కోరుకున్నాను అది చెప్పాను ప్రిపేర్ దాంట్లో ప్రాబ్లం ఏంటంటే అది సొంత తల్లి వారికి యాంటీగా నేను నాకు 2 అవ్వలేదు 307 2 కస్టడీలో ఉన్న 5 అవర్స్ చూస్తున్నది కదా 5 గంటలు చూస్తే 3 years మీరు ఇప్పుడు ఇక్కడ డిస్ట్రిక్ట్ సెషన్స్ ఎక్కడికి వస్తుంది కోరంటే ఏదో వెళ్తుందా 1987
ఒకరు నెక్స్ట్ గవర్నమెంట్ వస్తాయి
ఇప్పుడు ఇస్తారు
Yes, sir.
elder sister.
That's where is she studying?
I thought I got it.
Master. Must have come from ఎక్కడి నుంచి వచ్చారు? లోకల్ 3 days ఉన్నారా? Serious मुझे पसंद that is the mental ज़्यादा जानना है just for so money ना यार नहीं कितने साल के बाद but I want to that yeah he did have them also fantastic I think 2017-18 19 Morning.
వీళ్ళని డాక్యుమెంట్ అయితే వాళ్ళకి ఇప్పుడు అది నేను నేర్చుకున్న ప్రజెంట్ సాఫ్ట్వేర్ అది సెక్టర్ అవుతుంది అది ఏది రాదు పది ముందు వచ్చి టైప్ చూసి ఏదంటే ఎంఎస్ ఆఫీస్ 2009 10 వెర్షన్స్ ఏవో వాటికి తెలుగు సపోర్ట్ చేయదు అని చెప్తుంది అదే నాకు ఇన్స్టాల్ చేస్తా ఉంటే అడిగాను చెబుతా అంటే సరే ఏం చేయటం లేదు పరిస్థితి కాబట్టి అదో స్క్రిప్ట్ వేసుకున్నాను అదో స్క్రిప్ట్ పది పక్కన నేర్చుకోవాలని చదువుతూ ఉంటాను ఫిల్ చేస్తాను తమిళ అయితే తెలుగులో అయితే పాత్ర వెంకట పద్మ పదకొండు అయిపోయినారంట నా పేరు ఎందుకంటే మనకి ఇన్కేస్ టెస్ట్ చేయడం లేదు అది తెచ్చుకోవడం లేదా సిగ్నల్స్ అయితే తెచ్చుకుంటారు అంతే కాబట్టి జగన్ కాబట్టి ఇంకో వేరియంట్ వస్తుంది కానీ మనకి ఏది రాదు తెలుస్తుంది కదా చెక్ అందుకే అది నేను అడిగాను సిఎఫ్ఎస్ డైరెక్ట్ ఒక ఆయన మాట్లాడి చేస్తాను మనకి ఎందుకంటే మీరు ఫ్లైట్ ఎంత చూస్తాము ఇండియాలో ఎక్కడ ఫెసిలిటీ లేదు ఎందుకు లేదంటే ఆయన ఎక్స్పీరియన్స్ నడిపిస్తున్నాక అది లేదా ఎక్స్ప్లెనేషన్ ఇచ్చారు అదేంటంటే పాలన టెస్ట్ ఎందుకు పాలన టెస్ట్ అంటే అక్కడ రికగ్నైజ్ చేసిన కంపెనీ 3-4 ఉంటాయి ఆ 3-4 కంపెనీకి సంబంధించి ఎవ్రీ ఇయర్ వాళ్ళు తయారు చేసిన ఒక ఫోన్ ఇస్తారు అదే ఇదేంటే వేరియంట్ వస్తుందండి ఈ సంవత్సరం వేరియంట్ ఈ సంవత్సరం వేరియంట్ అవుతుంది ఆ కోడ్లు అనేది సిఎఫ్ఎస్ అని పంపిస్తారంట వేరే వేరియంట్ రాగానే కోర్టు మ్యాచ్ చేస్తారు వచ్చారు వాళ్ళకి వచ్చేసరికి సంవత్సరాలు ఇంకా తయారు చేస్తారు ప్రైవేట్ అఫైర్స్ గ్రూప్ ల్యాబ్స్ వచ్చారు కదా ఆయన సెకండ్ అఫైర్స్ డైరెక్ట్
వెళ్ళాము ల్యాప్టాప్ టూల్స్ అనేవాడు అది పుట్టే నేను నా సీనియర్ సార్ వెళ్ళాము కేంద్ర అయ్యండి ప్రాబ్లం వచ్చి డేటా ఉంటే 15 రోజులు ఫస్ట్ సపరేట్ కేబుల్ తయారీ
చేస్తారా
మనకి తెలియదు కావాలి అంటే వేరే ఎక్స్ట్రాక్ట్ చేసి
Game show.
అది
restrictions. So basically, last time
పైసలు ఉంటాయి ఆయన దగ్గర గౌతమ కదా ఆయన ద్వారా ఆయన వెళ్ళిపోతున్నారు మనకి కావాల్సినట్టు
పదహైదు ఎక్స్పెక్ట్ చేస్తాను
అలా ఏమీ తీసుకున్నాను కండిషన్స్ అన్ని ఫుల్ఫిల్ చేస్తే అదైతే కండిషన్స్ అన్ని
సెట్కి రాజమండ్రి సెవెంత్ బ్యాంక్ 9:30 తర్వాత
जिन्ना साहब ये बात मत पार्टी बढ़ते थे उस कांग्रेस के आगे वाले मुसलमान थे उनके नुमाइंदे मुसलमान थे शिकार रंगे अबू बकर ऐसे माहौल में कर्म मुतहन दाखिल था
ईश्वर की पूरे कल की आजादी में पेशकश की मौजूद थे जो कॉन्स्टिट्यूएंट असेंबली में जमा होगी एक आजाद हिंदुस्तान की तारीख
My colleagues stand here for the defense of the good of India. Other matters are not given to this, and they will be discussed and decided in the Constitutional Assembly, which will make a project for a meeting of parties. Dreams that may turn into nightmares for the Muslims of this country if we allow the Congress to prosper. That's why it's imperative that we Muslims of India have our own group of states that we decide to the Constitution. We don't believe that in violence. All of the cities on these states like Punjab, Pakistan, and North Central province will form the first. And the states under the law will be the same. Separate from the public. The rest of India and what happens is
हिंदुस्तान के पूर्व में असम और बंगाल और पश्चिम में बाकी के भारत में राज्य सरकार खुद अपना लेकर क्योंकि संचालन कांग्रेस के
Things are evil.
అది ఒకటి ఫైవ్
Groups of officers they should we are only against the position and that is and that's one issue and it needs responsibility to the which
సही కట్టి లోపలికి మండే ఉంటే వెళ్ళొచ్చు ప్రిపేర్ అయినందుకు బాగా
హలో వినిపిస్తుందా హలో అలా వినిపిస్తుందా మీటింగ్ దుబాయ్ వెళ్తావా మెసేజ్ వచ్చింది వాళ్ళు దుబాయ్ పోటీ పట్టి పెట్టారు దాని పక్కన హలో
That's why we need so that the person is free in their own bodies.
అంటే ఏసీలో కదా ఇక్కడ ఇప్పుడు ఇంటిమేషన్ ఎవరికి ట్రాన్స్ఫర్ చేయొద్దని మనం ఎంఆర్ఓకి నోటీస్ నుంచి
ప్రాసెస్ ఫాలో అవ్వడం పొజిషన్
ప్రాపర్టీ డీటెయిల్స్ వల్ల వాళ్ళు 90% విలేజ్ అయితే ఓన్లీ
నేషనల్ అజెండా సెటిల్ చెప్తాం అసెస్మెంట్ అంటే టోల్ నెంబర్ మాత్రం ఏదో స్ట్రక్చర్స్ ఉంటే లోన్ అనిపిస్తారు.
సో మనం కాన్ఫిడెన్స్
చేయొచ్చు.
చేయటం
Remember submitting the trial and
రెవెన్యూ విలేజ్ డయాగ్రామ్
injection has to be done. Yes.
ఇస్తారా పర్సన్ నేమ్ మీద ఆర్ఎస్
ఇస్తుంది.
పేరెంట్స్ ఉంటే కనుక కొంచెం మేము చిల్డ్రన్స్ అక్కడ కంపల్సరీ సైన్ పెట్టాలి కదా క్లాస్ అక్కడ పెట్టాలి అదే మధ్య పేరెంట్స్ వాళ్ళు చిల్డ్రన్స్ లేడీ అన్నమాట మన బ్రదర్స్ చెప్పకుండా చేస్తారు.
వాళ్ళు చేసే కార్డిక్స్ చూసినప్పుడు ఫ్యాన్ కంపెనీ సెక్షన్ లేకుండా చేయలేదు సార్ మాస్టర్ డిపెండెన్స్ అందరూ ఉండాలి. ఒకటి ఇస్తారు డిపెండెన్స్ అందరూ ఉండాలి. కానీ మేము ఏం చేస్తామంటే ఎంతమంది విషయం చెప్తే సబ్మిట్ చేస్తాం.
సో చెప్పడానికి అవాయిడ్ చేయడానికి అనేది ఇచ్చారు. ఆ టూ ఏదైనా మాట మాట్లాడతాం. సో చేస్తే వీళ్ళందరూ వచ్చి కూడా ఆయన వస్తున్నారు. వీళ్ళేమో కూర్చోవట్లేదు.
అప్పుడు ఏం చేస్తుంది అంటే దొంగతోడు నోటీస్ చేయండి. వస్తాకి నోటీస్ తీసుకుంటాం. కాంప్లైంట్ కొంచెం
ఎవరో ఒకరు తెస్తే సరిపోతుంది.
నేను ఎన్వైరన్మెంట్లో టీచ్ చేసేదాన్ని, ఫ్యామిలీలో ఇంట్రెస్ట్ చేశాను ఈ సెమిస్టర్. చాలా ఫ్యామిలీ
చేస్తాడా?
అలాగే చేస్తున్నారు. చేస్తున్నారు. ఆఫీసర్ రిపోర్ట్ చేస్తే పాస్ చేస్తాం. ఎక్స్ప్రెస్ పాస్ చేస్తే వెంటనే సాధ్యం. ఈ IPC like
ఉందండి పర్మిట్ ఏం చేయాలి తెలుసుకున్న తర్వాత
నువ్వు ఏం చేసావు వంట చేయండి చేసి వచ్చాము కంప్లైంట్ అక్యూజ్ ఏం చేసినది హైకోర్టు వెకేషన్ కోర్టుకి వెళ్ళదు వెకేషన్ కోర్టుకి
ఏం చేయట్లేదు
ఎగ్జామ్ డేట్ పోలీసులు కంట్రోల్ చేస్తాం అయితే సఫిషియెంట్ స్టాఫ్ లేదు చూద్దాం ఎట్లా సో అప్లికేషన్ ఆర్మీ కోర్టు కమ్యూనికేట్ అవ్వాలి సో ప్రాబ్లం అంటే మాకు ఫ్రైడే ఆప్షన్ సాటర్డే కాఫీ తీసుకోవాలన్నా మండే అవుతుంది యాక్షన్ పిచ్ అది 5 పిచ్ తీసి లోపల వాళ్ళు తీసుకొచ్చి చేస్తారు అండ్ పోతే హైకోర్టు ఆదేశించి అంతగా లైక్
సీరియస్ ప్రెసెంట్
సెషన్స్ అనుకుంటే బయట చేసుకుంటారు
Good morning to everyone present here. It is with great warmth and respect I welcome you all to the final day of our legal refreshment program, a gathering that has over the past days sparked meaningful dialogue with weekend legal insight. Today marks not just the conclusion of the program, but the culmination of shared learning, exchange of experiences, and reformation of our collective commitment to the rule of law. We are truly privileged to have amongst us galaxy of eminent learned judges, senior advocates, and distinguished judges who have graciously agreed to share the knowledge with us. On behalf of the organizing committee, I extend a heartfelt welcome to each one of you. May today's session be as enriching as the days gone by. Let us make the most of this final opportunity to learn, reflect, and engage. Thank you and welcome once again. I once again welcome all the dignitaries to this 3-day residential orientation program being organized by the Bar Council and Bar Council of Andhra Pradesh and Damodar Srijoya National University. I request our Honorable Sri Nallari Reddy Garu, Chairman, Bar Council of Andhra Pradesh and President of the Institute to come over the dais and around the chair. I request our Honorable Student to present the document of Honorable Chairman. I also request the chief guest of today's function, Honorable Sri Justice Chinnamma Rajagara, Judge, the Principal District and Session Judge, Visakhapatnam, to come over the dais and around the chair. I request our fellow student to present the assignment to his lordship. I request the guest panel of today's function, Honorable Vice Chancellor Sir Ramadan Sanjeevaya National University, Professor Dr. Isuna Prakash Rao Garu, to come over the dais and around the chair. I also request our fellow student to present their sampling list. I request the guest of honor of today's function, Honorable Vice Chairman, Council of Andhra Pradesh, Sri Secretary Krishna Garu, to come over the dais and around the chair. I request our fellow student to present the sampling to Krishna Mohan. I request the guest of honor and program coordinator Sri Ganda Ram senior advocate and member of Bar Council to come over the dais and around the chair. I request our fellow student to present the sampling to Brillas. I request the guest of honor Sri Ravi Gubela Garu, member of the Bar Council to come over the dais and around the chair. I request our fellow student to present the sampling to Sir. I request the guest of honor, Sri Narasimha Garu, member of the Bar Council to come over the dais and around the chair. I request our fellow student to present the sampling to Sir. Now, I request Vandana Reddy Garu, Chairman, Bar Council, to preside over the program.
Honorable District Judge of the great Discharge, Excellency Raja Garu, Vice Chancellor of this great Ramadan Sanjeevaya University, Prakash Rao Garu, my colleagues, Vice Chairman Krishna Mohan, former Vice Chairman, and the other member, Mr. Ravi Gubera, and also Ram Raoji. How nice it is for the 2 days we completed this the past orientation programs. But 2 days, when we had actually for part of 3 days, we were having a thought of only for 2 days. But the orientation program, because the people are coming from the stores, so they entire it's not my job. People from far away places like Purdue, Kannur, and other places. This is a unique situation because one of the Bar Council started particularly the programs, either at Vishaka or Vijayawada or other places, only the local people are attending the one-day seminars. This particular seminar got its own future. That the entire state is represented. Now I already told you, we completed 2 days of the program. I felt very happy of particularly all the speakers They spoke on various subjects and educated you of particular law and law subjects. My only request is, I know many of you that you made a job of the activity when you go to a bar association. Make yourself 10 or 15, 20 members sit together and explain what Justice Karana Sharma had said, what Justice Nageshwara had said, what Justice Nagarjuna had said. So all these persons, do you think they came here just to speak something without reading? What I felt it after hearing them, I hope you also might have felt that they have spent much of the midnight hour to prepare themselves physically, mentally, and morally. So this is the type of the things our speakers has gone through it for 1 or 2 days. So make it a point that your presence itself has to be given a presence in your partnership. So all the members join together, explain together, particularly for the young advocates. I request you to educate them on the particular lines whatever Honorable Guest has delivered different types of lectures. I'm very, very happy that we got one of the finest vice chancellors. And the first day itself, I said, one of the tallest man in the Indian political community, one of the tallest leader in the Indian field, one of the tallest advocate in the Indian field, Damodaram Sanjeevani. Hail him! And on his name, this particular university is named by the government. I salute we our Navy officers who are responsible for naming Damodaram Sanjeevani. It's an apt name. I already told, not only as a lawyer, not only as a legislator, not only as an advocate, not only as a second chief minister of Andhra Pradesh, and later on, he is a cabinet minister in Indian government, and later on, he led the entire Congress party for 2 terms. How great a personality! How great a personality! We are proud that he is our Telugu man. Hey, you sir, wherever you are there, we are under your guard. This particular building, that is shades of you his, and I like to our vice chancellor. Thank you very much. Now I request today's morning session, Raja Garu, to deliver his.
This is VA awareness and ability. I told her how to do it. Chairman of the Bar Council and members of Bar Council of Andhra Pradesh, other dignitaries and players, staff here, and advocates. Good morning to Mananda. Thank you. Hello, Chairman. AP. Partners of Andhra Pradesh. Refer to my name. His address. It is my duty to introduce myself to the gathering. I am General Secretary, Principal, District and Certificate, Visakhapatnam District. It is my privilege and pleasure to address the gathering in the presence of jurist in my opinion, C.A. Ariadna Sarmagar, JMG, High Court of Andhra Pradesh. Of course, I felt some nervous, even then I will move further. Before going to the subject, I want to say few principles. Everybody knows that law is not static. We have been observing day by day new case law, which we will not accept. Therefore, this type of programs periodically is required. For which I am thanking the Bar Council of Andhra Pradesh for conducting this program. Second one is we have to keep the same in our mind. Law is of two types. Law made by legislature or parliament, and the second one is judgment law. That is case law. It is settled that case law prevails over the law. When there is conflict between law and case law, we have to follow case law. I think maybe our human agree that is a different aspect. For which I will give one example. In 304A of Code of Criminal Procedure, R is used. Accused can be on conviction. Accused can be imprisoned or can be fined. R, not end. Court, the magistrate cannot be forced. Both as per law. But the judgment law says that when once conviction is recorded, you have to impose both imprisonment as well as fine. So, judgment law, rather case law prevails over law. If any magistrate follows section 304A and he imposes fine only on conviction for deprivation of section 304A, that means I think the higher ups may find fault with him. He has to mandatorily he has to impose both imprisonment as well as fine. That is the law made by Supreme Court. They made the such law in view of the rampant road accidents in India. So coming to our subject, first one is rejection of pain. To curb the vexatious and sham litigations, this provision has been enacted. Why this provision is enacted? Can't we check the plaints at the time of numbering? We can curb it even at the time of numbering itself. When it is curbed, sham and vexatious litigation, we curb at the stage of numbering. I think the filing of application under Article 7 Rule 11 for rejection of claim will not arise. Why this provision is enacted? Again, the reason may be at the time of numbering, the registering authority may not look into the facts in deep, whether it is vexatious litigation or strong litigation or useless litigation. All these things, I think, at the stage of numbering may not be scrutinized. Therefore, the authors of Code of Civil Procedure enumerated this Article 7, Rule 11 of Code of Civil Procedure. Then, when the application for rejection of claim under Article 7, Rule 11 can be filed, law says at any stage it can be filed. There is no limitation or whatever it is. At any stage, the application for rejection of claim can be filed. And another civil principle of law is that piecemeal rejection of claim cannot be made. In the sense, one prayer is, I think, is rejectable, and even then claim cannot be rejected. The other prayers are sustainable. When other prayers are sustainable, claim can be rejected when all the prayers in toto are rejectable. So, with this background, I want to read for the benefit of us the provision Article 7, Rule 11 of the claim shall be rejected in the following cases. They enumerated 6 grounds to reject the claim. First one is where it doesn't disclose a cause of action. The cause of action is silent in claim, it can be rejected. Second one is where the real claim is undervalued. If one shows the less value of the property than the market value, the claim can be rejected. But firstly, court will return the claim for correcting the valuation. And even then, if the party doesn't incline to rectify the valuation, then the claim will be rejected. And the third one is when court fee is not properly paid, the claim can be rejected. For this also, the court will return the claim for payment of deficit stamp duty. And the party doesn't incline to pay the court fee, the claim can be rejected. In case of B and C, court will give opportunity. Straight away they will not reject the claim. They will return the claim for rectifying the valuation as well as the court fee. And the next one is when the claim is barred with limitation, court will reject the claim. At this stage, for this point, some clarification is required. In case of class D, when a claim is barred by litigation, Supreme Court said that the claim cannot be rejected at the point of litigation because it is a mixed question of fact and law. At the threshold, the claim on this point of litigation cannot be rejected. And the parties have to face trial, and then only the limitation has to be decided. And at best, the Supreme Court observed that at least a preliminary issue in respect of this limitation aspect can be framed and decide the matter. But the claim cannot be rejected at the threshold. While numbering or at later stage, if the court feels or on the application of the defendant, if the court comes to conclusion that the claim is barred by limitation, the claim cannot be rejected. Because limitation aspect in most of the cases, it is a mixed question of fact and law. When there is a fact to be decided, claim cannot be rejected. If the limitation aspect is purely a question of law, I think it can be rejected. Say for example, promissory note. Today it is excluded. Everybody knows that the suit can be filed on 14th day of I think 25, 26, 27, 28 of this month. If the plaintiff is filed beyond that date, what is the, I think there will not be remedy. In that example, the claim can be straight away rejected. Almost, I think in property matters, I think litigation aspect will be a mixed question of fact and law. Say for example, in a suit for social whether the parties are ready and willing to perform the part of contract. I think always it is a mixed question of fact. It is to be decided after full-fledged trial. So, on the point of limitation, at the threshold, in I think in title matters or property matters, the claim cannot be rejected. And the other two aspects, they are not of much significant, where it is not finally duplicate. Claim is not finally duplicate and rejected. I think it will be returned and they will file automatically the duplicate claim. The last two aspects are not of much importance. And nextly, undoubtedly it is a security principle of law, so far as the rejection of claim is concerned. Both has to consider or has to examine or take into consideration only the evaluation of claim. The case of the version of the defendant cannot be considered while doing the application for rejection of claim. He files written statement, this is my case, this is my version, these are my documents, please see the documents and reject the claim. That type of argument cannot be accepted. Only the claiming elements and the document filed by plaintiff, filed along with claim, only are to be considered for rejection of claim. The case of the defendant cannot be looked into. Then the other aspect, Supreme Court, Honorable Supreme Court held that the plaint cannot be rejected on the ground that the case of the plaintiff is hit by res judicata. Res judicata aspect cannot be decided at the threshold. Only after trial that point is to be decided on the ground that the defendant will show by filing some documents. Sir, the plaintiff is liable to be rejected as it is hit by res judicata. No. The case of the defendant cannot be looked into. Plaintiff only has to be seen. Even then, on the point of res judicata, the plaintiff cannot be rejected at the threshold. And time, I think, short I have to complete by 11. Then I will go to the other subject that is discharge of it. So that is rejection of plaintiff in civil. This is a discharge of accused in criminal. Our lordship just now in the honorable VCC chambers that you selected one vegetarian subject and non-vegetarian subject. So, but the result is one and the same. Plaintiff is rejected, there will not be nothing. When the accused is discharged, there will not be nothing. Therefore, on that reason I selected these two subjects. Discharge of accused recently our Honorable Supreme Court, so far as discharge of accused is concerned, on 22/5/2025, Honorable Supreme Court held live law reporting. It was reported in live law. Like the plaintiff governments only are to be considered so far as rejection of plaintiff is concerned. But discharge of accused also, court must peruse prosecution's materials, but not the material placed by accused. Same phenomena. Only the case of the prosecution shall be considered for discharging the accused. Accused may show some materials that on the basis of these materials I may be discharged. No. His material cannot be considered for discharging of accused. Only the material furnished by prosecution shall be considered for dealing with the applications filed for discharge of accused. That is the law made by Honorable Supreme Court recently on 22/5/2025. That is the case related to Exabat. State represented by Inspector of Police, CBI, Visakhapatnam versus Yeluri, Srinivasa Chakravarti and others. Hitherto, we are in some notion that for discharging the accused, sometimes we have considered the material supplied by the accused. That is not correct as per the Supreme Court. When there is no prima facie material produced by prima facie case produced by the prosecution, then only he has to be discharged. Live law 2025, live law, Supreme Court 633. So far as law is concerned, for discharge of accused, under CRPC, in sessions cases, under section 227 of Code of Criminal Procedure 1973, the application for discharge of accused can be filed. Now, under BNSS, it is 250. 227 is rather changed to 250. So far as sessions cases are concerned, and both the sections are one and the same, but there is one limitation as well. For filing application by the accused in sessions cases for discharge of accused under section 250 of BNSS, the limitation is 60 days from the date of commitment of the case by the magistrate. On one day or the other, the magistrate will commit the case to the sessions division. So, from the date of committal, the accused has to file application for discharge of accused. In this connection, you may ask that for sending bundle, I think the magistrates sometimes will cause delay of more than 60 days. Then how the application is to be filed? So, in my opinion, but I do not know whether in this connection any genuine law comes or not. In my opinion, that application has to be filed before magistrate within time. Then he will send that application along with the bundle on a future date. So the accused may not say, since the bundle is not sent to the sessions court, I did not file the application for discharge of accused. Therefore, now you may receive the application. He cannot ask the sessions court like that. After committal, he can file application before the magistrate concerned. Magistrate will send the bundle along with this application. That is PS. Something means PS. Then the sessions court will number the sessions case as well as this application. Then the sessions court will hear the application for discharge of accused. So that point has to be kept in mind. The limitation is very, very important and serious. After 60 days, the accused cannot file that application and he has to face the trial. And another provision, so far as warrant cases are concerned. For warrant cases, the accused shall file application for discharge under section 239 of CRPC. Again, now it is 262 of BNS. Here also, same limitation, 60 days. That is from what date? From the date of supply of copies. Here, no problem because this matter, I think, will be tried by magistrate. The application has to be filed before him. So far as sessions cases are concerned, here I said that the application within time has to be filed before the magistrate. If bundle is not received, if bundle is received within 60 days by the sessions court, he can directly file application before the sessions court. So here also that limitation is enumerated. That is from the partition of copies to the accused. And one more, I think one more trial is there, that is warrant cases relating to private companies. Warrant case, trial of warrant cases is of two types. One is cases instituted upon police report, that is charge sheet. Warrant case instituted upon private company. So for this, earlier section is in CRPC 245, now it is 268. Under 268 there is no limitation. 268 of BNSS, no limitation is prescribed. That means, as earlier we did, the application for discharge can be filed at any stage. And one more trial is there for summons cases trial. So where summons cases trial is concerned, there is no provision either in Code of Criminal Procedure or in BSS for discharge of it. Even then, as per legitimate law, the accused can file application for discharge. Even in summons case, summons trial, Supreme Court observed, Honorable Supreme Court observed in such a way, in a case K. Matthew versus State of Kerala and others, reported in AR 1992, Supreme Court 220. As per the law made by Honorable Supreme Court in this case, the accused can file application even in summons cases for discharge. From common sense point of view, when there is no charge, there is no discharge. In summons cases, I think we will not really charge. Even then, there is no prima facie case against the accused. He can file application to discharge me from the case. As for this. I think I touched the subject superficial. But not indeed. Now I was given time 10 to 11. On time I am completing. Thank you very much. And I thank the Bar Council of Andhra Pradesh for giving this opportunity to share the few points which are in my knowledge. I think the Honorable JK will appreciate whether there is any wrong with me. I think the Lordship will correct the same. Thank you very much. Thank you, one and all.
Thank you, sir. Your presentation is informative. Now, prestige the chief guest.
As we conclude this session, I take the opportunity to express our sincere gratitude to Sri Chinnamsetti, Principal District and Sessions Judge Vishakhapatnam, for delivering an insightful and practical lecture on rejection rate and discharge of accused. His experience and analytical approach enriched our understanding of procedural nuances in both civil and criminal law. We are grateful for the clarity and depth he brought to the subject. Thank you, sir. For the next session, I request the Chief Justice of this function, Honorable Chief Justice Harinana Sharma Garu, Judge, High Court of Andhra Pradesh, to come over the dais and acknowledge. I request our faculty Gurukul Prasad sir, along with Nagarati Garu, to present the sample cruiser. I request the guest of honor of today's function, Sri Nagarati Garu, to come over the dais and adorn the chair. I request our student to present the sample to I request the guest of honor, Sri Posai Venkateshwara Garu, senior advocate and private acting prosecutor, to come over the dais and adorn the chair. I request our fellow student to present the sample to sir. I request the guest of honor of today's function, Sri Nagarati Garu, advocate and private acting prosecutor, to come over the dais and adorn the chair. Apologies.
Welcome, sir. Honorable Sri Justice Harinana Sharma. Well-known personality as far as the Shaka district is concerned. Because here, teaching and session judge were well-known man, young, of the white jet. This judgeship records and also Government of India recognized his services as a district and session judge and appointed him as Honorable Judge of Andhra Pradesh. For the presentation, particularly on the subject of implementation of criminal laws, focus on FIR, registration, competence, petty process, challenges, and other things. And moderated by none other than former public prosecutor and a member of the Bar Council, Mr. Nagarati Garu. On the other hand, we got a senior advocate, former public prosecutor of Andhra Pradesh. We got the right persons here. We all members are going there. There will be presentation on the screen. Thank you very much. Yes, please.
Very humble good morning to one and all. I have said applause and congratulations to the partners of Bangladesh and team of partners under the steering of program coordinator in London and member of Council of Bangladesh. Special mention about the Chairman Council of Bangladesh in Jordan and his esteemed team of members of Council of Bangladesh. Equally those to Tamil University and his Vice Chancellor Professor D. University and board of managers from the end of government and university, particularly the students. A lot of enthusiasm, zeal, and interest to be seen from the dean, also the officer. What is doing in this program? Special appreciation and congratulations to participants, the young advocates who came from across the state, the 30 cities, to take part in the pre-licensure legal profession program to improve the skills of advocacy. Working of 2 weeks of the career of justice, the bar and bench together for 2 days. And this prestigious institution like Government University is likely really a wonderful and unforgettable event for everyone who is taking part in this event, including me, appearing as a right occasion. The objective of the program is to improve the skills of advocates. After this hours in the system, from the bar and the bench, testing for almost 2.5 days, and I was the last batsman in this. I am conscious of the fact that everyone is in a mood to log out and thinking of their retirement and planning for regular professional work before the course with all vigor after the summer vacation. The warm-up you had for the 3 days here, before entering into the actual phase in the court field, will be helpful to all its, not merely to the advocates, even to the courts, the same is going to be helpful. The thought of arranging the program just before the opening and leaving one day break is really laudable. Particularly the spirit of the program and the topics selected, including the players from both ends, creating a good mood and good environment involving encouragement on various aspects, generating inspiration to work with all commitment. It is highly difficult for me and my co-panelists, the lost players on the field, to maintain the tempo the earlier speakers maintained from the dais. Yet we will try. Further, it is difficult to hold and keep all of you attentive during the last technical session. Also, when you are waiting for validity session, also delicious dinners, lunch, etc., you are going to have. And the presence of attentive personalities like Justice Shivapat Ravi Garu, some of the soil, and the others, the professor, Vice Chancellor of University, Surya Prakash Rao Garu, the organizational chairman who has been of course for all these days, the other team, Prasanna Garu, Vice Chairman, and other. members of the board, not council. Anyway, having been asked to discharge the highest responsibility of sharing certain thoughts with you all, we are before you with all the enthusiasm to share something we know, but to learn more from you all. I'm told that there will be a interactive session in here and the question hour also, and we will be asking something and we will be sharing something, whatever we know, and the innocence, intelligence, ignorance, whatever it is, all of us are going to share and have something productive out of our discussion. I take the privilege of presenting my co-panelist, Sri Osari Venkateswara, Namaste sir. Senior Advocate, former public prosecutor, Sri Y. Nagareddy garu. Of course, they are already introduced and presented. With the permission of my co-panelist and the presidium, I proceed with my further presentation with a caveat that my team of co-panelists are others at liberty to intervene wherever they want to supplement and add energy. Now, probably, I'll be walking around with the permission of all of you and the presidium. Before going to actual thing, one thing I have forgotten to add, of course, advisory, brother, etc., investigative, post testing, and it was kind of in the idea that if something is there to be connected and have to connect. It's not a question of connection, always adding something. Hope I am audible to all of you. Last, audible, sir? Not audible? No.
Use phone microphone.
Hope now it is fine. Nice of you. Repeating the concerns and thanks to host district, the bar of host district and the district of the Visakhapatnam. I will mostly for that. Only thing I want to supplement because the liberty is given by my brother as to conflict between the judgment on the statute law, what is to be. Of course, it has become a practice and it is invoked that we look at the judgment law and we follow it because it is ready to use, ready made. After checking out something and after working out on thing, we get it, so we use it. That is but however, see the sources of law because many law students are there. The sources of law is more reliable and more authenticated source of law is the statute. So judgment law, precedent is the second source. And wherever it is a question of interpretation, either done in consonance with the statute, then probably for interpretation purpose, whether how it is interpreted, to understand the interpretation process, we look at the judgment law, except on that, adding of that, nothing to be added from what my brother said while speaking earlier. Now, coming to the topic proper, for which we are here. First July 2024, new criminal laws. FIR and charge sheet on the subjects now in specific we are going to touch upon, and the other of course is the ocean. If we go we can't come out. I am conscious of the time constraint. And the discipline my brother Chinapsi Prabhu followed is that although the train started late, he could complete it on time. And our train started right time. If I cross the time, probably I will not be doing justice. I will try to do. Even if I exceed, I think we may bear it. I'm sure that we will not exceed. We will try to be on time. Now, among the law students, anybody first year to third year, post law students from the advocates. Junior advocates, 1 to 3 years standing, below 3 years standing. Very good. Yeah, oh fine. One of you, can you please stand? 3 statute names without.
BSS.
No, I want full form.
भारतीय न्याय संहिता.
न्याय संहिता next other.
भारतीय नागरिक सुरक्षा संहिता.
Right.
भारतीय साक्ष्य अधिनियम.
Wonderful. So first learning of the name, and there is lot of difficulty in just chanting the name. We have accustomed to IPC, NSI, and CRPC. And abbreviational use of the statute name. For that also judgment was necessary. Precedents will depend on the precedent that whether Indian Penal Code is to be used as IPC, whether Criminal Procedure Code is to be termed as CRPC, whether DNSS is to be used or the RTA Nagarika Suraksha Samhita is to be used. For that, High Court had to say. High Court said that after High Court saying that you can use DNSS, you can use US, now it has become. So let us try to come out of that kind of things. After all, it is just for the communication purpose we use it, and that's one thing. Fine. Now, this kind of new laws coming in, is it for the first time in the century? Is it for the first time in the world history? Many times, many new laws have come. As far as CPC is concerned, new laws, amendments have come. Completely repealing has taken place, and new law has come. As far as the ERPs also, whether we had experience of giving go by to overcome and getting new law. Can anybody help me in possessing such experience? Whether she completely CRPC and no CRPC or not? Anybody can help me? Is it only for the first time DNS coming and CRPC watch out and earlier for the such experience?
It was there earlier.
Only amendments is there. Complete moving coming, substantial changes to the picture. Following the earlier code of procedure. Prior to 1973, now BNSS, prior to BNSS, and it is 73 CRPC. Prior to 1973 CRPC, what was there? Wonderful. 1898. So 1898 has gone, 1973 has come. Like the 1973 has gone, and BNSS has come. Now, are we scared of BNSS? Are we afraid of BNSS coming into field? If at all fear is there, at what point is fear is? Number of sections. 302, 302, 302, 307, now 302 has done some other section has come. That is the only difference. The only number is changing. Same person, same ingredients, same thing, only number blank, board alone is same chemical. Now there is the full code, probably may wear half code or may wear full code. But it's only this. The person is same. Almost the principle is same. So that is it. So what are there is any worry in our mind that something absolutely has we have a new planet, don't be afraid of that. Same thing is there, only the color is changed and the code is changed. Very one thing. So now the goal is here, whether it is 15, 42, 44, 40, etc. How will you do it? So it will certainly only minor adjustments are taken as that's all. What is the change? It will be very easy. Then this adjustment process, How it has taken us in 1974, 1973 CRPC has come after 1898 CRPC, 1973 CRPC has come. 1973 CRPC, there are also many differences, many changes have taken place. Prior to 1973, there was communal, there was a detailed inquiry, the evidence is to be collected, evidence is to be appreciated, and detailed cross-examination was there, everything was there. There was revision of election in 1898 CRPC. Revision of election was there in the district court, session court from the 96. And other again the Indian was to the High Court. How many revisions are 1 lakh to 1 lakh? There is coming a lot of time. Where there is only one revision, the revision is there by the district court. Let there be no revision. In fact, he brought in 1973, which was there in 1898. How that was addressed? During 1973 to 78 or 1980, by the Indian Commission, if we look, now the same thing now we can follow. Brother was referred to case law. So the case law began 1973 to 1980 with regard to interpretation of the CRPC. 1973, with reference to 1898 CRPC, if we see the interpretation process has changed, the same policy, same principle, same ideology we can follow now also while adopting BNSS. Am I confused or am I confused? Will you agree with me? Am I clear? Is this topic clear? Right, clear. Okay, I'm happy with this. Fine. Now, what is the logic behind that? Then, 1989 has gone, 1970 has come. Whether 1898 comes also can be seen. Whether BNSS has come, whether CRPC 1973 is again. Whether still that can be looked into. If I say that yes, that can be looked into, will you offer me, will you accept? BNSS has come in the place of CRPC. I say that even CRPC has to be now looked at. People would have done it in 1973 CRPC, you have to look and you have to follow. If I say, will you accept or will you not accept? You will not accept. How many will accept? I will not accept. Accept conditionally. Accept conditionally. So unconditional acceptance is not there. Conditional acceptance is there. What conditions are now? We are change. First, my topic heading is that we are change. Change how it should be understood. For that purpose, I am doing all this. So conditionally, we can look into event earlier one. So, what is that condition? For certain purposes, it can look into, for certain purposes, it cannot be looked into. What are that purposes? Pending. So far as the pending matters are concerned, earlier thing, so far as the new is concerned, only new. What is the basis of this distinction? Pending that is కొత్తగా మీకు నేను రెండు పుస్తకాలు మెయింటైన్ చేయాలా లైబ్రరీ ఆల్రెడీ రీజన్ బేసే లేదు లైబ్రరీలో లేదు అదే వాయి ఎగ్జామ్ కలపి జల్దీ ఎగ్జామ్ రాలేనా డిస్ట్రిక్ట్ ఎగ్జామ్ రాలేనా టు ప్రిపేర్ అండ్ లుక్ ఇంటూ సో మెనీ థింగ్స్ దెన్ యు ఆర్ ఆస్కింగ్ us to go to what is the fun and what is the logic in looking at this too? What is the practical base? What is the logical or legal base for that? Can you refer absolute or can you show your finger at particular statute or particular ruling number by this preposition matter? We have to look at both. 531. Okay, BNSS 531 is one thing. Even before going to 531, are there any other principles that guide us to look at the existing one? Can you guide me? Can you take me to any particular provision of law, particular legal principle for that purpose? Wonderful. The doctrine of traffic to obligation, the doctrine of traffic to obligation. Again, you are referring me, you are taking me to doctrine and principle only. My request is on the provision. My request is that can you place, can you drive me to every particular provision? Article 20 of the Constitution, subject of my brother. You are referring that constitutional perspective also. Yes, expose facto law. Expose facto law to a fact that has occasion, that has happened. A law that has come into force subsequent a fact cannot be applied. Law is exposed facto cannot be applied to a fact already happened. That is protected. That cannot be applied is what? The constitutional protection under Article 20 clause 1. Fine. Okay, I'll come to the other end also. Whether it is only for criminal law or any other law. I say that for other law also there is a principle. Can anyone of you take me to that provision which guides us to look at any law, not mere criminal law? Hope 1 to 3 years. Any other? 3 to 10 years. Any other? Constitution of India, just of the discussion about 20 class 3, 20 class 7. Have you heard of General Class Act? General Class Act. Wonderful. General Class Act, any particular provision can you drive me? Section 6 of General Class Act. If you see, you will have a mantra, a permanent mantra is Section 6 of General Classes Act in respect of adopting and applying and understanding the change in law is the Section 6 of General Class Act. Even in the absence of any particular provision, brother was referring to 531 of VNSS. 531 of VNSS saved 1973 CRPC. Okay. Even if 531 was not there, even the legislature slept over or did not think of having the 531, still General Classes Act 6 would say that whenever any new law is enacted, it will not disturb, it will not take away any right, obligation created under the existing law. The obligations continue to exist, the rights continue to exist is what the spirit of the Section 6 of General Classes Act. This is one thing. So, backdrop is General Classes Act, Article 20 Constitution. In this background, we need law, change in law is fine. Next. Now, 531, what is the head of 531? What is the heading of 531? Repeal and service. Do you find the same analogous provision in BNS 358? 358? Is it 358? Is it 358? Do you find it in Indian? This is what is made 170? So, all the three enactments, BSA, BNSS, BNS, are having the provision, dealing with the provision of repealing and saving. This provision, repealing and saving, if you see, each sub-provision under these three provisions, 351, 358, 531, and 170. These three acts, you see General Class Act, General Class Act, 99% of the language is the same. Section 6 of General Class Act language, 352 language, 522 language, 358 language, and 170 language is almost more than 90% is the same. So, repealing and saving the importance of repealing and saving. Whenever you read any statute, firstly we have to look at, we have to look in, we have to bear in mind, we have to be mindful of repealing and saving. What is repeal, what is saving? What is repeal, what is saving? ఇంట్లోకి రాగానే కొత్త కోడలు వస్తుంది కొన్ని అక్కడగా నేర్చుకున్నా కొన్ని పనులు నువ్వు చేయమా అని ఎలా చెప్తారు కొత్త పనులు చేసుకొని నువ్వు పని చేయమా కొన్ని పాత అక్కడగా నేర్చుకోవచ్చు చెప్పినట్టు పాత ప్రొవిజన్స్ కూడా అప్లై చేయాలి సేవింగ్ అక్కడగానే రిపేరింగ్ అక్కడగానే పక్కన పెట్టి కొత్త కోడలు మొత్తం పని వెరీ సింపుల్. So we need to keep this ideology, this principle, then we need a statute and we can make use of it to a maximum to one place. Next, while reading the statute, every statute generally will have 4 components. statement of reasons and objectives. The purpose for which a statute is enacted. Secondly, the definition clause. The words important are discovered and removed in a statute, how they are to be understood. Thirdly, the body, what exactly it is dealing with. And lastly, the remaining savings. The last one, remaining savings, is hard according to me. If you are thoroughly that and you will be making good use of the connection. So this is one thing to be treated. We need to go and the importance of doing such is such. So these all provisions you can read. Okay. Consequences of being common law doctrine. That's whatever aspect is there in the slides that will be shared. No issue. Section 6 of the Discharge Act. This is 358 BNS. BNS. Then that one of BNS. Okay, repeating is not for first time. Earlier also was there, 1973 CRPC, 484. Earlier section 484 of CRPC was there earlier. When 1973 Act has come, 484 was there, which is similar to 531. How 484 was implemented in the transitional stage between 1973 to 1980, judges case, referring of case, he wanted to refer to case, how the calculator is to be applied and implemented. Please refer how 484 was implemented in the recent experiment 3 to 80. The principle and analogy with which it can be interpreted improvement. For that purpose, this implementation. Next, constitutional perspective is arbitrary. Doctrine of beneficial constitution. Here, I take a pause. Now, old law is to be applied, new law cannot be applied. Why? Where a right is created or obligation is created, that our right or obligation cannot be taken out. So, at the time of commission of the offence, 3 years punishment is prescribed. Subsequently, 3 years punishment is increased to 5 years. Take 354 of IPC for the matter, outraging of modesty. At one stage, the 5 years were there. At one stage, the punishment has come home. And commonality also changed due to change of regime. And state amendments are also affected. In one state it is compoundable, in another state it is not compoundable. Recommendments how it should be understood unacceptable. Now, at the date of the commission of the offence, the punishment is something. And subsequently the increase, when you accept the increase of the punishment, alternative is decreased. It was earlier 5 years punishment, now it is 3 years punishment. The legislature has taken the view that punishment 3 years punishment is enough. The legislature takes a step. And the law is amended, making it a lesser punishment. Now, can you collect the benefit or can't you collect the benefit? My question. How many of you say that? How many of you say that? Higher punishment should be imposed despite the decrease. And I am now we are not IFL judges now, we are just academicians, just we are discussing academics. How many of you will agree that because the law and the date of commission of offence, the law and the fact has occurred and the law is there and that factor is a particular fact, that law is to be applied is what Article 20 Constitution says, 21 says. Then can you say that no, to decrease, please decrease? Have you read any provisions under the DNS that where the punishment is reduced? It's not reduced. Don't ask me what are the provisions. Our piece of homework morning, Vandana Reddy was referring to what spoken from here and fall into teams and discuss what is the point right and just churn it so that the academic churning will be there and some kind of cheese will come out of it, water, the message of the president. So, it's a homework for all of you. Fine. So now, again, I will not leave that question. can you ask for lesser punishment?
Community service was included for
No, community service is a kind of thing. I appreciate. Fine.
fine or community.
Okay. So I am on the point. I am on the point. Is punishment pattern is at state as well as the community services center. I am on the point. The lesser punishment is imposed. Whether the lesser punishment can be brought into picture, can be demanded of. Retrospective. Retrospective. My question is whether lesser punishment can have retrospective effect is my question. How many of you say no? How many of you say yes? Any no's? I think motor, probably everyone will assure and not, I don't know. Sir, what is your stand? No arrest, I don't want any explanation, yes or no? No means only higher punishment is to be imposed. Okay, all of you will agree or anybody will decide from him? So dissent is there. So how are you going to dissent from it that the lesser punishment is to be imposed? How do you justify that the lesser punishment is to be imposed? Wonderful, wonderful. So beneficial construction of the legislature, always the Supreme Court judgments in number of cases said that if you start don't ask me citation, just I wrote the citation, there are citations. I don't have time. I'm done with me. So first out I have just exploring a thought for igniting your mind's thought process. Legislative benevolence, please capture the word. Legislative benevolence. లెజిస్లేచర్ ఎక్కడైతే క్షమ చూపించిందో ఆ క్షమను ప్రతి ముద్దాయి కోరుకోవడానికి అర్హుడే. సో ది లెజిస్లేటివ్ బెనవలెన్స్, బెనిఫిట్ ఆఫ్ లెజిస్లేటివ్ బెనవలెన్స్ అండ్ బెనిఫిషియల్ కన్స్ట్రక్షన్ can always be demanded and it can be asked whether they demand or not. The court is going to extend the benevolence which is contemplated by the legislature. This is another philosophy of the law. So now lightning round. They were heavy lightning round. I was under the impression that some law students are also there. There I can clarify. Thank you. All of you are practicing in High Court only. High Court, forget about High Court, High Court. Some good number are there and some High Court. Majority are from the High Court only. Very good. Magistrate courts, district court, sessions court, magistrate court, and India magistrate courts. చాలా తక్కువ 20% కనిపిస్తాయి. Magistrate and sessions court రెండు ట్రయల్ వస్తాయి. బట్ magistrate court అనేటప్పటికి చేతులు కొద్దిగా తప్పుతా. So lot of law, lot of crime, lot of need, and lot of necessity is there in magistrate courts only. Kindly don't have any a lesser fee for a magistrate court. More need is there in the magistrate court. So I request and I appeal to all of you, embrace as far as possible the magistracy also, so that you want to have any correction as strong foundation with clearly from the magistracy. From there the revision to the session court, from there to the High Court, the matters will do come. So try to next. So now, who are on course? All of you want to continue in the course, or you are searching for judges jobs, prosecution jobs, company laws, corporate side, litigation lo hogalanuntunnara, ikkadana bike vellipovalanuntunnara. Any one of you who are searching for other opportunities can just for my help. Nobody? Ever unnara? You want to go for corporate or other than litigation? Other than what made you go for other than litigation?
Already yesterday we had a discussion.
Oh, I am sorry. I dropped that question. I dropped that question. So my working on my concern and my request is that don't drop out in the biggest punishment system. A good grades and good things must continue and have a consistency, and then the profession will have its own. Don't drop out. Never drop out. patients are waiting to pay you. Only thing availability, only thing you are available, అమ్మ అన్నం పెడుతుంది నువ్వు అక్కడే ఉంటుంది ఉంటే అన్నం పెడుతుంది నువ్వు వెళ్ళిపోతే అన్నం పెడుతుంది. Now 154 FIR ఈ సబ్జెక్ట్ అకాడమిక్ సమస్య అకాడమిక్ అకాడమిక్ చేసిన ఇబ్బంది వల్ల అసలు దానికి రావడానికి ఎగ్జామ్ పట్టింది అరగంట పట్టింది. సో FIR అనేది మన సబ్జెక్ట్ కదా, FIR 154 కదా, 154 ఆబ్జెక్టివ్ ఏమి, 154 ఆబ్జెక్టివ్ ఏమి society criminal law and motion. The problem 154 next is society criminal law and motion. So fine, society criminal law and motion. Who will set the criminal law and motion? Who will set the criminal law and motion? Police will set the criminal law and motion or anybody will set it? Complainant is the right word or any other right word is to be used? Environment. 100%. So we are in the stage of improvising and fine tune. So the words and language also, let us be as near as possible to the statute and let us be as near as to the form that are present. But it affects the beauty of your expression. So information is the appropriate word. Fine. Whether FIR should decide in every case or need not decide. నీటా డిసైడ్ కావడం చెప్పలేదు. ఎందుకు ఎప్పుడు సమ్టైమ్స్ మూడు చెప్పారు కాబట్టి సైన్ చేయలేదు. ఓకే, అప్పుడు కూడా సైన్ అప్పటికి అక్కర్లేదు, అప్పటికి అక్కర్లేదు, అప్పటికి అక్కర్లేదు, తర్వాత చేయాలి. ఎప్పటికీ అక్కర్లేదు ఏమైనా ఉన్నాయా? ఎప్పటికీ అక్కర్లేదు ఏమైనా ఉన్నాయా? అక్కడ ఉందా లేదంటే అక్కడ ఉంది ఖచ్చితంగా. అప్పటికి అక్కడ లేదు, తర్వాత అక్కడ ఉంది. ఒక సిచ్యువేషన్ ఎప్పటికీ అక్కడ లేదు లేదంటారా? సంతకం రాదు. సో కాలి ప్రశ్న ఇస్తుంది. అప్పుడు సైన్ అనేది ఎవరు సైన్ చేశారు అనేది ఇంపార్టెంట్. Who has to sign? Important has to sign. Police sign చేయాలా, గవర్నమెంట్ sign చేయాలా? గవర్నమెంట్ sign చేయాలి. ఇది కేసులో గవర్నమెంట్ sign చేయాలా, ఎక్కడానికి గవర్నమెంట్ కాకుండా వేరే వాళ్ళు sign చేయాలా? Police officer he is important, so he is not signing. No problem. He is signing. He is important, he is signing, no problem. Other than important signing circumstances, other than important can sign. Minor, wonderful. Next. He is saying not minor, but on behalf of somebody, whether only technical official or anybody can sign, anybody can give information. Anybody can give information. So it is not always necessary that only the technical has to give information. Anybody can give information. And to get this information, and the benefit will be more than the next. There are larger issues. Purpose of this being the criminal law. Do you find any other provision in CRPC which deals with setting the criminal law? Complaint is also. So committed in his presence, in his court, you can make that difference. My answer is not this. I'm on the point of setting the criminal law in motion, any other provision of law. Section 31 of statute. Section 39 of the statute says that every person who is aware of submission of a confidential case has a duty and obligation to report. It is referred to 51A duty, fundamental duty. It could have never taken a constitutional particular provision. మీరు రిపోర్ట్ చేయాలి, చేయకపోతే మీరు తప్పు కన్సీలింగ్ సమ్టైమ్స్ కన్సీల్డ్ కాంప్లికేషన్ 201, 202, 203 కూడా వచ్చి దూరం వెళ్తాయి. So it is obligation on the part of the citizen to report about the time, and everyone is competent. Who is competent to set the criminal right motion is every person who is aware of the commission of fundamental offense is competent to set the criminal right motion. It is not because competency. It is a duty. It is an obligation, and the statutory obligation to report about the knowledge and information, transmission of information to police. Probably. Nuevo, ignorance of law is not an excuse for the system. When you are knowledge, you have to inform. Okay. Okay. Fine. Okay, the organizer, my appeal. Whenever you want me to shut, I'll shut. Okay. Fine. So welcome on behalf of the organizers, Honorable Deputy Secretary, Sir, Namaste, and good afternoon,
Sorry.
It's our pleasure, sir. Thank you very much.
No next time.
Please, sir, please.
After 12:30, we can have.
Sir, whatever time, and probably even my brothers are also, co-families are also there. They will share something. Okay, friends, please take care. Please take your respective seats. Friends, please take your respective seats. Almost maximum I take for another 15 minutes at my co-family still, and I hope whenever necessary I will try to add something wherever I feel like. So now we are on FIR. I was referring to the obligation of the citizen under section 39 of the CRPC, and it's as well as right, not only a right but also an obligation to set the criminal law into motion. The moment you set the criminal law into motion, it will be set in the form of FIR. FIR is given. Ignorance of law is not an excuse. There is duty. Fundamental duty is there. Statutory duty is there. If before they don't register. They don't register. Whether 154 speaks of anything as to the obligation on the part of the state to register, obligation for the citizen to give complaint is recognized under 39 and it is there, we all agree. And obligation on the part of the police, obligation on the part of the investigating agency and the police is there or not. It is certainly there under 154, they have to register, fine. It is beyond the obligation under 154, if there anything is added to that here, I would request all of you to say, go through thoroughly. It is running into 120 paragraphs. Nalanda Kumari case is a classic case. It has a driven, and the sea change is there in the jurisprudence related to the registration of FIR, and a lot of mandates are given by the Honorable Supreme Court in Nalanda Kumari 1 and Nalanda Kumari 2. Nalanda Kumari 1 was of the 2-year ban, and the panel comes before the 5-year bench in Nalanda Kumari 2. Nalanda Kumari 2 guidelines are such. Registration of FIR is compulsory. In the judgment, if you go through, you will come across, you will see. The one I have reported just now is also discussed. You are asking the citizen to compulsorily report, and you are not registering. And you are registering with some speed in cases, not registering with the same speed in another cases. Why are you that speed? Why are you that slow? Therefore, it is must and should for you to register the FIR whenever the complaint is given by the rider is that it must disclose commission of a cognizable offence. It must disclose the commission of a cognizable offence. What is cognizable offence? I don't go deep because the time is very short. where the police officer can arrest without warrant is a capital offense. Broadly, possession of a punishment basis are there. They are possible offences. So, where it discloses the commission, then you can say that it is disclosing, whether you can say that it is not disclosing. Again, the question. Always one statement call you, construction call you, relaxation call you. Relaxation we don't satisfy. Laws enacted in the British period, if you see old laws, every session will have a relationship of 5 or 6 legislations dealing with the different conditions, circumstances or regions. The law is there. Now it's not there. However, we have it. So, where it is disclosing computable effects, where it is not disclosing calculable effects. I will give you an illustration. This is only for classroom purpose, don't cite anywhere. In my game also very class. But I guided the discipline for ఒక సిచ్యువేషన్లో ఒక వ్యక్తి ఎవరైనా నా ఫ్రెండ్ పాకిస్తాన్లో ఉన్నాడు. పాకిస్తాన్లో ఉన్నటువంటి ఫ్రెండ్కు ఆగస్ట్ 14 రోజు ఒక మెసేజ్ పంపిస్తాను. హ్యాపీ ఇండిపెండెన్స్ డే పాకిస్తాన్. Happy Independence Day of Pakistan. Happy Independence Day of India is August 15. August 14th is Independence Day of Pakistan. So I give you a message that Happy Independence Day of Pakistan. Let us celebrate. And the things happening here are not that comfortable. And the application of 370 is one such circumstance I am feeling worried. Is also my message. What it is said. The message said. Then basing on that, FIR is registered. Now the offence is a seditious offence. Maybe 153A of probation or whatever the provision of the seditious is what the allegation made against me, one of the persons who got that message, who had access to that message. Maybe it's my public video or WhatsApp video which I sent to group in which my Pakistan friend is also a group member. I sent that message. Basing on that message, FIR is registered. Now you say that there is a calculable offence. These things likely to happen in the course of a journey. If you see a decided case now, in a similar circumstance, it is said that expressing good wishes to another national who will have a friendly gesture does not amount to any provocating the animosity among the other thing or hatred against your nation, which approach you are meeting the other nation who are your friend. It does not amount to any hatred. It is not this national exhibition of your handiness. It is not there in this message. It is first standard observation. Second observation, that application of 370 is not happy with me. I am not happy with the application because it is done is what is taken. Whether this will amount to provocating or promoting any kind of animosity is the next question. For it also the observation is very right? No, we do does not amount to freedom of speech and expression guaranteed under 19th Constitution. So, according to the opinion expressed, democracy expects the freedom of expression and the freedom of speech and expression is expressed that there exists no element and class of that. Fine. Come to the illustration, I come to the next illustration. Without the scenario, ఒక పోయం రాస్తాడు ఒక కవి. నేను మాట్లాడితే రాజ్యానికి కోపం వస్తుంది. నా రాజ్యం కోపపడింది నా మాటలకు అంటే నా కోపాన్ని కూడా సంతోషంగా తీసుకుంటాను, నేను కష్టాన్ని కూడా సంతోషంగా తీసుకుంటాను. నేను నా కుటుంబ సభ్యులు, నా మిత్రులు, నా ఇష్టమైన వాళ్ళ యొక్క రక్తము రాజ్యానికి ఇష్టమైనట్టయితే అది దారిపోయడానికి, నా స్వతంత్రమైన భావాలు వెదజల్లడానికి నేను ఇష్టము అని ఒక కవిత రాస్తాను. ఈ కవిత రాజ్యానికి వ్యతిరేకంగా ఉందంటారా లేదంటారా? So, this is indicated that it is an expression of anti-national tendency and anti-communal tendencies are very expressed in this Anitrakta. Chapter Guru. సున్నితమైన విషయం, గంభీరమైన విషయం కానీ జరుగుతున్నాయి. అప్పుడు మీరు నేను ఇక్కడ చెప్పి అక్కడ గుర్తించిన రైటింగ్ అని చెప్పట్లేదు. అకాడమిక్ డిస్కషన్ కోసం తిరుగుతున్నాను. I go by meeting. So the meaning principle is this. In this simple material, possibly one response after the registration of a parent, question of a parent, question of a parent, judicial intervention, scope of judicial intervention, all these subjects do come. Fine. And this is also a common statement in because these two statements are cases होता रमदू बड़ा रमदी का बड़ा no, you cannot crash. But can't challenge it. That is situation. He sometimes based on the data that accusation and it's a payload law. Reminder approach చేయగలరా ఈ టెక్నికల్ బేస్ చేసుకొని ఇలా సర్కమ్స్టాన్సెస్ అప్పుడు చేయకుండా చెప్తే మీరు ఏం చేస్తారు మా యాక్సెస్ ఏం చేస్తారు నేను చూసుకుంటా మా అకాడమీలో మేము చూసుకుంటా బెంచీలు చూసుకుంటాం ఒక బెంచీలు ఏమైనా చేస్తే పైన ఏం చేస్తారు అనేది చేస్తారు బట్ యాజ్ అన్ అడ్వకేట్ ఇవి ఎక్విప్ అయ్యి ఈ సైటేషన్స్ ఎక్విప్ అయ్యి ఈ స్టేట్మెంట్ లో and already stated to the statutory provision. Are you ready to point, figure out, argue, present, and question? My question. Please be ready. Please equip yourself. But don't be result oriented. Effort oriented. Detach the effort oriented approach will give you the result at least 2 courses if not immediately. It will certainly give lay a foundation how approach is what I do. So go through this thing. Now setting it in motion. Now it's only in respect of cognizable offense. Non-cognizable offense lo kuda FIR register cheyocha. Non-cognizable FIR unda. Is there any step for registration of FIR in non-cognizable offense? What is the other way of non-cognizable offense? Private complaint. So the situation is that even if non-cognizable offense is informed to the police did not register the FIR for registration of FIR, permission of the magistrate is necessary. 5155 of CRPC, they have to seek permission. Again, the situation was that whenever environmental offense is there, the court has to refer the information to the magistrate and magistrate has to interview the permission after notification of the magistrate, the FIR is to be registered by the police and the investigation will be done in what is the effect of non-cognizable offences question. So this is sorry, hope the track is going on. Fine. So, after the Supreme Court intervention and interpretation of the law, they are complaining about the lawlessness. It is offensive according to the non-cognizable etc. If you say that it has to go, how much of hurdles, how many problems, how many intermediaries will be there, and how much of hand lifting is necessary in the process, you have to imagine. So, imagine all the things in hand, job of the informant to go to the magistrate to have the permission, etc. You police related to magistrate, not done, what the guidance. So, now the obligation, it is recovering matter or recovering information. They will take, then what is that they have to do? They have to enter the information in somewhere, they have to enter
General line.
So GD is the concept. Happening to GD. Is there any other document equal to GD maintained by police? Anybody can help me? FIR register. FIR register will be there. FIR will be there. FIR register will be there, and GD will be there. GD and FIR. Is there any difference between GD and FIR? What is the difference, sir? Difference between the GD and FIR. GD will have information of every information, every information, whatever is GD basis police manual 1939. FIR basis CRPC. So the conflict between the supremacy identity of GD and FIR therefore you cannot have the supremacy of GD over the FIR. So GD had another thing. GD లో కూడా answer అయినా అనుకోండి assistant answer in the sense satisfied with the condition of the appliance I record otherwise I will not record. It is the liberty, the laxity there in the course manual to enter in GD. Whereas the same thing always because the details in GD, details are register same. So I apply the same analogy as to my duty for maintaining GD or maintaining an argument was there. Nothing doing Babu. The FIR is having the data sampling. Your obligation to register the FIR more signal, more standby, more rigorful than that of entering into GD. GD is for looking your performance by your superiors. But FIR is looking by the public as to your response for the grievance and the crime against the society. All standards concerns of the authority and normally the other defenses, you can, as far as the FIR is concerned, delay. How many of you say that delay is fatal? I will come to your question after this answer. How many of you say delay is fatal? FIR లో delay ఉంటే FIR పాస్ చేసేయాలి. FIR చల్లదు delay ఉంటే ఎవరైనా చెప్తారా? ఇంకా delay ఉన్నా పర్లేదు ఎప్పుడైనా మిస్టేక్ అయిపోతాను. So, people from case, circumstance, then what is the explanation? Then what is the excuse? What is the excuse you can have for the delay in registration letter? What is the excuse you can have?
What is the reason?
Wonderful. So there will be a column in the FIR, column number 8, wonderful. So it provides stipulates for mentioning the reason for the delay in registration of the FIR. The delay is justified. పోలీస్ స్టేషన్ పక్కన పక్కన వెళ్ళి నాకు 3 రోజులు తర్వాత రిజిస్టర్ చేశాను. పక్క ఊళ్ళో జరిగిన ఎఫ్ఐఆర్లో అర్ధగంటలో రిజిస్టర్ చేస్తా అంటారు. సార్ రీజన్ నాకు రావడానికి ఇన్ఫర్మేషన్ రావడానికి లేట్ అయిందా? పక్కన ఉండేదానికి పక్క ఊళ్ళో గంటలు వచ్చేసిందా? So there you can catch the reason, the justifiable reason is always a reasonable reason. Not a reason for reason's sake. So you can attack the delay, you can attack the reason. You can attack the justification, the reason mentioned in the FIR, all provided for mentioning the reason. This is how the reason got happened. So, obviously, delay is not fatal, but delay creates wonderful doubt. Another qualifying adjective, reasonable doubt. When it creates a reasonable doubt, then you can see what. So that leads to something. I'm talking to that. Now 154 does not speak about the electronic registration of FIR. In fact, 173 now the latest provision is also contemplating the electronic communication of FIR. So maybe it's a FIR. Many communication policies made ఉన్నాయి. మరిలో భాష పాత్రలుగా చూసింది రిజిస్టర్ చేయాలా లేదా ఈ వాంట్ it has to be registered, but the writer and the uncertainty that within the signature of the information is to be applied. Previous time is to be there. It is again an interpretation. The informant has to sign signature of the informant is to apply in 3 days. Whether it's on signing in 3 days. More interpretation possible by one side FIR is to be registered on signing within 3 days. Signature is to be obtained within 3 days. Informant has to sign in 3 days. Open discussion. This electronic communication registration of FIR signature without participation. Whether in all cases signature is necessary ante -2 and so on insane will have some exceptions. Now in case of internet communication and electronic communication FIR is registered and constantly in America. He has sent the mail and now he is not in India. He has to communicate with rights and other things and take all of months here. Then in that scenario what is going to happen is a challenge. In the process of our journey to how we develop, how we wish to be. Maybe it is maybe signing before the campus is there. These are all the things which are in a sense, they are all the which are waiting for that. But As far as the information is reachable, they can can be applied by going to him, asking him to come, they can come. Not sending you to the separation, you said you want to know these things. So you are referring to something, please. Zero for I will do that. Fine. Wonderful. Yes. Thank you for the feed. That point actually I can have skipped that. Zero FR is a concept which I have seen under the title recent DNSS. Even prior to the zero FR was there. Zero FR was there under administrative instructions. What is zero FR is and what are the earlier experiences? Municipal players, Idaho players are commanded in more realization. So we will get to compare and discuss it. Then if you vegetarian government signature started like an unnecessary subject of salary. Parallel. Tasting. Tasting చెప్పకూడదు I'm tasting. So ఇక్కడ నా పరిధిలో లేదు కాబట్టి పోతుంది పోలీస్ పోలీస్ మూవీస్ నా పరిధిలో ఇంకో వేరే పోలీస్ స్టేషన్ చాలా కంపెనీ బాగా వేగాలు చెప్తే ఏదో రోజులు పట్ట వేగం అనుకుంటుంది అంతే now this registration of మొత్తం ఏం చేయాలంటే ఇంటిమేట్ కాకుండా నీ పరిధిలో తీసుకొని ఆ పరిధిలో పోలీస్ స్టేషన్ పంపించు దేని ఇన్ఫర్మేషన్ వాజ్ రిసీవ్డ్ and the information was transmitted. వాడికి ఇన్ఫర్మేషన్ తీసుకొని పంపించే వాడికి వాటికి అకౌంట్ అనేది చేస్తాడు ఆయన ఎత్తిన వేగం పడుకుంటాడు జీవిత అకౌంట్ అయిపోతుంది సో దాన్ని అనేది so no you sending the same paper okay you may send to management that you enter in your register FIR register that is funded so to police station register that is and zero statutory activity లేదు అభివృద్ధి ఒక ఉపయోగించి ఎలా చేస్తాడు మందులు వెళ్తారు ఇలాంటి ఆర్గ్యుమెంట్స్ వచ్చాయి పోలీస్ స్టేషన్ how the FIR can be registered in respect to of the jurisdictional number and then the FIR register would be transmitted to the concerned police station by the police district or the FIR. So police station complaint submit the FIR in the police will register police synchronization in and major part of telling the next place is the legal record follows, then they are charged. Charging also will be filed in electronic form with what you see the provisions, specific provision comment, the parallel or 173 of the existing PRBC. Even charging can also file in electronic form. Then how it will be consumed, how the process, how the transfer papers are, how the papers are, how to be supplied, in the electronic form of provided, digital form of we are saying the electronic form is not sufficient, digital form also as a process are necessary for saying the digital form. So this is what I think.
Meanwhile, my brothers want to say.
That's it. These are quite very
So now, have you heard of successful FIRs and secondary FIRs and multiple FIRs?
Yes.
Sir, please, sir. You want to get some rest with the relaxation? Sir, why? So, multiple FIRs is one thing. Successive FIRs is another thing. Two FIRs are same incident is another thing. Have you heard of all these things? Some of you might have seen that also. If you have any experience on that, I'll be happy to share your experience on that. Multiple successive FIRs and two FIRs in respect of one matter. If so, what is the situation? There can be two FIRs in respect of one incident.
Previous one, in the first
So now, reasonable exposure to the point. In the statement, example ichchanu I visited a Pakistani national my friend with Independence Day, and I said about this that not one at Bangalore one FIR, at Vijayawada one FIR, at Visakhapatnam one FIR, at Kendur one FIR, whoever to the matter has been circulated, in all stations the FIR is registered. In respect of the same incident. Can it be said as multiple FIRs of same incident? Multiple FIRs of same incident. Multiple FIRs of same incident. Is it permissible? No. Not permissible. But how do I know that Vijayawada police station that the complaint is already given at Bangalore? So then for this purpose, consultation of FIRs at the earliest place or the comprehensive place where all FIRs are to be brought there, judicial intervention, High Court will interpret and say that all FIRs are to be brought at one place and the matter can be tried. The other things will become the ancillary. So, I and my friend, Srinivas, president, we fought something. And I am annoyed by Srinivas saying something and gave a report. Srinivas also, he also gave a report. With regard to same thing. I gave it to 10 mark, he gave it 10. I said that he went with the stick and he said that I went with this marker. Fine. Which has happened, most of it has happened, sex is okay. Two things have in fact happened. Now whether the two affairs are there or only one affair will be there. Two affairs can be there. So, genesis of incident may be there, but the effect of the incident may have multi effects and both may be aggravated. But here the another point is what made him thinking and what made him thinking. He said something, I said something. Who said first? Who said first will become who? Who said next become who? Who said first become the aggressor? Who did something will become the aggressor? Who has provocated the other? He delays and will do something. In the process of defending myself, I have told this. And in the process of getting serious relationship with his hand. Then it's a defense and it's an aggression. So aggressor and defense, both the case and counter case is also possible, and case and counter case you come across. My FIR is registered. First, no, my case is true. I say, no, here management got in the FIR first is therefore my case is true. You will go with whom? Whether the registration of FIR in past is going to be a merit, or the registration of FIR and content of the FIR is going to be a merit. So the registration does not, the time of registration is not going to be the criteria, the matter for any consideration. Only the content of the material is going to be the consideration. Why? So now, delay in FIR, I was referring to PhD doubt. Whether in respect of accident cases, we shall discuss. The number of cases delay in the registration will there. The principle, be it an accident case, be it any case for that matter, whether the registration of FIR is important or what is important. So treatment to the victim, rescuing the victim is important, and that registration of FIR, giving of complaint, all that things. So whenever you come across a situation, these limits at this point, please bear in mind. Evidentiary value of FIR. FIR is a substantial piece of evidence, whether it can be whole and soul. It can be whole and soul. It is corroborative. It is corroborative. Whether FIR can be used for both corroboration and contradiction, or it can be for only contradiction, or it can be for only corroboration. Both corroboration and contradiction. Fine. Can I have what is the difference between corroboration and contradiction? If I already covered it 2 days, I don't make it to go there. If not covered, somebody may let us try to venture difference between corroboration and contradiction. Is it covered? Yeah, any feedback, any thought on corroboration and contradiction?
Corroboration means it supports the case. Contradiction means against the.
That's right, sir. Contradiction is a destroys the doubts, sir. It's going to help to decide the veracity of something is a contradiction, which is going to help in the corroboration. So FIR can be used for both corroboration and contradiction by whom? Whether the accused will use it for corroboration. Prosecution. Only corroboration. Prosecution can use it for contradiction. So accused can use it for contradiction. Prosecution can use it for corroboration. Accused can use. What is the other statement that we use it for corroboration? 161 can use it for corroboration. Whether 161 can be used for corroboration? Anybody say that it can be used for corroboration? 161 corroboration use ఎవరున్నారా? ఎవరున్నారో ప్రాబ్లం ఏంటంటే మా జడ్జెస్ యూజ్ చేసింటారే మరి. అప్పీల్ గ్రౌండ్ ఫస్ట్ గ్రౌండ్ అదే పెడతారు. 161 మీద కన్విక్షన్ ఇచ్చారంటే ఎలా ఇస్తారండి? అసలు 161 మీద కన్విక్షన్ లేదండి ఏం చెప్తారు? So 161 cannot be used for corroboration. 161 is for only contradiction done by the accused only. Fine. Now, evidentiary value of FIR is certainly an important piece of evidence. It is not a substantial piece. It is to some extent substantial piece of evidence. It is an important piece of evidence, but it is not whole and soul. You cannot completely decide on FIR. Only one case there FIR can be 80 to 90% can be decided in a new case. Because of section 476 baby order which says that FIR cannot be decided. It's a law is there. 176 of Discharge and 476 of Honorable Court said that it can be used for avoiding the compensation, not for culpability, but for deciding the entitlement of the claimant for compensation. FIR can be used for motor vehicle use. Otherwise, by itself cannot be the complete basis. Okay. Next. So, if I go like this, now probably I think there are so many things, as I said, it's a motion, it's going to be a marathon. If we go like this, not all the day, this is someone medical will also come and said that I break, facts you break, and you have written plans for also all there for shine more and be doing nothing of you all. So, I want to just share that with my friends and they will add something and you will also contribute something so that the actual design program of some kind of interaction also is possible. Many good friends are so we'll have which permission for all of you and the president and others. I take a box here, not there. Positive of value. Thank you, one and all.
participants to kindly stay back.
అయిపోలేదండి ఇంకా ప్రోగ్రామ్ ప్లీజ్ కూర్చోండి.
The session is not yet complete. We request all the participants to kindly come back and take seats. The session is not yet over. We request all the participants to kindly come back and take your seats.
Hello. My dear advocates, after 15-20 minutes, we'll have a tea break before we'll take into consideration of the mandatory address. Please sit. Yes, very nice. Thank you.
Now we request an esteemed speaker, Naikreddy Garu, to preside over this.
Honorable Justice Agarnath Sharma garu, Honorable Justice Shivapat Ravi garu, Honorable Chairman Sri Dwarkanand garu, Senior Counsel former PP Sri Kosa Venkateswar garu, and all the dignitaries on the dais and off the dais, and my dear advocates. Just now, Honorable James clearly spoke about FIR and then multiple FIRs. Recently, you have come across this kind of multiple FIRs in our state and country. That is the Arnav Goswami case. Please go through it. And also T.T. Antony case. These two cases are celebrated cases. Please go through them because there are so many FIRs. Are concerned, they have to conduct the preliminary inquiry. But my confusion, subject to Honorable Judge intervention, now preliminary inquiry as far as CRPC is 173 without prejudice to the provisions contained in section 175 on receipt of information related to the commission of any cognizable offence which is made punishable for 3 years or more but less than 7 years, the officer in charge of the police station may with the permission from an officer not below the rank of deputy superintendent of police considering the nature and gravity of the offence proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the manner within period of 14 days or proceed with the investigation when there exists a prima facie. Here, it is very silent. whether this preliminary inquiry is after registration or before registration is silent, that has very gray area and it's my doubt. Yes. But in Lalit Kumari, preliminary inquiry before registration. Registration of FIR is mandatory as per Lalit Kumari, but as far as preliminary inquiry, see whether there is any prima facie case or not. Here,
the theory of a preliminary investigation has been brought into the through method. The concept of 154 is and should be restriction on the respect of algorithm analysis. Unless and until there is any cognitive evidence, not the situation of the crime, it should be. Well, if any doubt arises, whether it is a cognitive approach or then the theory of preliminary inquiry or where there is an anomaly in the present because there is no such a filter concept about theory failure. By of the BNSS 173, again it was brought into this type. Whereas there is an anomaly. Judgment law says only with respect to verify whether the cognitive offense or not. All investment other offenses like the matrimonial dispute, commercial disputes, corruption, and medical there is a delay. Whereas the 173, it was reduced totally by set time whether there is a prima facie case there. As for the judgment law, the investigating officer, while conducting preliminary inquiry, cannot go into the truth or otherwise of the case. The meaning of the to ascertain whether the prima facie case is there or not. And apart from that, in the judgment law, there is a prescription after conducting the preliminary inquiry. If the investigating officer does not want to proceed with the investigation, he shall intimate to the informant within 1 week. Whereas in the 173, there is no such prescription. On the other hand, it is left to the investigating officer to report to the superintendent of police. Then thereafter, it shall be reported to the magistrate, London magistrate. For what purpose? To ascertain whether any cardinal offense is there or not. To proceed further. There is another anomaly. So, section 156(3). The London magistrate, basing an application, can order for investigation. There, whether it is a cardinal offense or not a cardinal offense, there is no such distinction. But judgment law in Priyanka Srivastava case, such applications shall be supported by another condition. The informant would have, the complainant or applicant, whatever maybe, would have approached the SHO, thereafter superintendent of police. Those aspects shall be mentioned in the application. In the present section, that is 175 BNSO, such applications shall be supported by application. Whereas in the application to be submitted to the magistrate pursuant to the preliminary inquiry, there is no such prescription. These are the anomalies, and there is no time prescribed. That's why, unless or until preliminary inquiry is conducted, there shall not be any restriction on it. Can I add my thoughts?
Already I will take a question. It's a more scenario. Kumar case. Kumar case we could homework without sorry. 2014 2 SCC 1. 2014 2 SCC 1. My two brothers in second agree. Registration of FIR is mandatory. After registration only investigation is what the Supreme Court observed. Registration of FIR is mandatory where disclosure confidential offense అనేది Supreme Court చెప్పారా లేదా without there is no quarrel. There is no quarrel to the extent of registration of FIR where the information disclosure confidential offense. Final analysis. Second. Then preliminary inquiry challenge. Two other words. Preliminary inquiry is the another word used. Final basic case is another word used. The other one gets to discuss name of student. The moment FIR is registered, the consequences of arrest are nothing which will automatically follow. Therefore, registering FIR before preliminary inquiry is going to have a lot of consequences on the accused rights చాలా event అయిపోతాయి accused చాలా event అయిపోతారు కాబట్టి please do preliminary inquiry prior to registration of FIR then only register the FIR in the primary basis basis అంటే ఆర్గ్యుమెంట్ వస్తుంది దాని ఆన్సర్ చేస్తున్నారు ప్రొటెక్షన్ ఫర్ ది రైట్స్ ఆఫ్ అక్యూజ్డ్ వెనుకదే and information is to be transmitted that arrestation ఉంది protection ఉంది అన్ని ఉన్నాయి కాబట్టి registration of FIR అనేస్త మాత్రాన is not going to work. Let the registration of FIR continue. Registration of FIR is mandatory. నాకు అర్థమైంది రెండు సెకండ్ వన్ రిజిస్ట్రేషన్ FIR mandatory అయితే మరి ఎందుకు వచ్చింది అనేది అంటారు. ప్రిలిమినరీ ఎంక్వైరీ కాన్సెప్ట్ ఎప్పుడు వస్తుందంటే 2012 అఫెన్స్ జరిగింది 2025 కంప్లైంట్ ఇచ్చారు 13 ఏళ్ళు రెగ్యులర్ అవుతున్నారు 368 సిఆర్పిసి ప్రకారం వాళ్ళు రిజెక్షన్ చేసుకున్న అఫెన్సెస్ వన్ అఫెన్సెస్ మాత్రమే రిజెక్షన్ 3 years or 3 years or more than 1 year 3 years about that అసలు రిజెక్షన్ లేదు 168 సిటీస్ అయితే రిజెక్షన్ రిజిస్టర్ చేసేయచ్చు అన్నప్పుడు రిజిస్టర్ చేస్తుంటే కాన్సిక్వెన్సెస్ ఫాలో అయిపోయి కాబట్టి ప్రిలిమినరీ ఎంక్వైరీ చేయాలి. Before conducting a preliminary inquiry, if you register, police common ఉండదు common ఉండదు ఎక్కువ అంటారు మీకు అంత ప్రాబ్లం అయిపోతుంది. No registration of FIR and bail అరెస్ట్ చేస్తే ఇంపార్టెంట్ బ్యాక్మెంట్ ఇన్ఫర్మేషన్ ప్రొటెక్షన్ ఉన్నాయి అసలు రిజిస్ట్రేషన్ ఆఫ్ FIR ఉంటే మోస్ట్ స్ట్రాంగ్ అవుతుంది కాబట్టి ప్రొటెక్షన్ ఓకే. Then next to look at deeper. Before proceeding further with the investigation, in the categories of 5 cases, mentioned economic affairs, in all these situations, 5 circumstances contemplated, preliminary inquiry. So, registration matter is registered before doing that. ఇప్పుడు 170 కాంప్లీట్ వచ్చిన అక్కడ ఉన్నారు రిజిస్టర్ చేయకపోతే 7 days నోటీస్ ఇవ్వాలి నోటీస్ ఇవ్వాలి ఇక్కడ టైం పెట్టాలి లేదా అక్కడ మాత్రమే టైం లేదు ఇక్కడ టైం లేదా అనేది నెక్స్ట్ క్వశ్చన్. It says that 15 days time is given in society is given for 15 days. 15 days next question. 15 days how and what power the 15 days time is given in the next మనం చూసుకోవాలి. ఇక్కడ 175 పవర్ 175 పవర్ అంటే కాన్స్టేబుల్ ఆఫీసర్ పోలీస్ ఆఫీసర్ ఇమిడియట్ ఇన్వెస్టిగేట్ చేస్తారు 175 చెప్తారు. కాబట్టి వితౌట్ పవర్ 175 where the offense is between 3 years to 7 years. Offense is between 3 years to 7 years. Less than 3 years, 3 years to 7 years lower attack life so punishment ఉన్నప్పటికీ కూడా 3 years to 7 years పనిచేస్తున్న situations లో కూడా with the permission of the DISP, Deputy Superintendent of Police, man or above, proceed to hold a preliminary inquiry and go
173 1 below protection payment order. Proceed with the investigation. Proceed with the investigation. 173 for
When there is.
proceed with the investigation when there is prima facie case. So, proceeding with the investigation is prefixed with the condition precedent. Condition precedent is prefixed sufficient. Condition precedent is sufficient. Condition precedent is common winner. There is prima facie case. Proceeding with the investigation where there is prima facie case. So, prima facie case investigation proceed forward. So, what will it be? Clear ఉన్నటువంటి ఇప్పుడు ఇన్వెస్టిగేషన్ పెట్టాలంటే రిజిస్ట్రేషన్ అయినా ఇన్వెస్టిగేషన్ చేయాలి కదా నడుస్తుంది లంకకుమారి కేసులో ఉన్నటువంటి జడ్జిమెంట్ వైలేట్ కాకూడదు రిజిస్ట్రేషన్ ఎఫ్ఐఆర్ మ్యాండేటరీ అనేది వైలేట్ కాకూడదు ఎఫ్ఐఆర్ రిజిస్ట్రేషన్ అనేది ఫెడరల్ ఆఫీస్ అంటే ఉండాలి ఎంబర్స్మెంట్స్ ఉండదు అండర్స్టాండింగ్ ఉంటుంది పబ్లిక్ కాన్ఫిడెన్స్ ఉంటుంది రేట్ ఉంటుంది సాటిస్ఫాక్షన్ ఉంటుంది అని హైదరాబాద్ అవి రిజైన్ చేస్తూ చట్టకుమారిని వైలేట్ చేయకుండా రెండు క్రమంలో చేసినటువంటి చెప్తారంటే ఏ punishment is between the police and 7 years. All of the 7 years. After that is academic absence and public event corruption and fees and family cases and illegal cases and given registration చేస్తారేమో అని అనిపిస్తుంది హార్మోన్ ఇంటర్ప్రిటేషన్ అందరం చేయాలని అనిపిస్తుంది ఆవేశం తగ్గింది.
Anyhow, this is the area where some subsection 1 has to come to the rescue of all of us. Anyhow, there is some debatable point. My topic is that it's only 5 to 10 minutes. Impact of Constitution on criminal law. Because now we are seeing so many things. Just now, multiple FIRs. 154 says that first information report. How many first information reports on same issue, on same facts? When incident occurred somewhere else, now they are entitled to file n number of FIR and 0 FIR. Then what is the fate of the accused? Under these circumstances, Honorable Supreme Court and High Court under 226 and Honorable Supreme Court under the Article 32 come to the rescue of the citizen accused. That's why some safeguards were given under our Constitution, and the interrelation between the criminal law and the Constitution, everybody knows, those who are practicing in criminal side. As far as we need not read the whole Constitution, but when we want to do the practice on criminal side, at least we should aware of the Article 19 to 22. Unless we read them thoroughly, we cannot understand even CRPC also. Because within 24 hours, the accused once arrested, he has to be produced before the magistrate. It is the constitutional safeguard where it is stated no, Article 22(2). Yes. So the same is reflected in our CRPC where it is 58. New law. New CRPC 58.
person arrested not to be detained more than 24 hours. No police officer shall detain in custody a person arrested without warrant for a longer period than under all the circumstances of the case is reasonable, and such period shall not, in the absence of special order of a magistrate under section 187, exceed 24 hours exclusive of the time necessary for the journey from the place of arrest to the magistrate court, whether having jurisdiction or not. This safeguard was given under Article 22, Clause 2. Every person who is arrested and detained in custody shall be produced before the magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of the magistrate. So, within 24 hours, they have to conduct the investigation and complete. In case they fail to conduct, and then 167 old CRPC says that within 60 and 90 days, they have to complete the investigation. In case they fail to complete the investigation, what is there? What is the fate of the accused? Default bail. If this is the invention by the Supreme Court on the touchstone of the Article 22 and also fundamental rights. So we have to see just now, Honorable Judge said that Article 20, Clause 1, ex post facto law. No person shall be convicted of any offence except for violation of law enforced at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. So now, under new law 304A, earlier the punishment is 2 years. Now it is enhanced to 5 years. Now any accused cannot be prosecuted under new law under this doctrine ex post facto law. That's why we have to read the Constitution, at least these articles, Article 20, 21, 22, because A.K. Gopal case, Maleka Gandhi case, D.K. Bob's case, and Satpathy case, and all these cases, these are all from Article 21. So they have given much priority to the liberty of the citizen. Now, victim compensation is also invented by the Supreme Court, taking in the aid of Article 21. And Nandini Satpathy case, you all know very well that right to silence is also a fundamental right guaranteed under Article 20, Clause 3. Right against self-incrimination. So, Honorable Justice Krishna Iyer said that a person has the right not only to disclose something, he has the right to remain silent. But 161 says that the person who knows the facts of any case, he has to truly give answer to the questions posed by the investigating officer. But it should not be, that's why it is clearly (161) (161)(2). Such persons will be bound to answer truly all questions relating to such case put to him by such officer, other than questions the answers to which would have a tendency to expose him to a criminal charge or a penalty or forfeiture. Here, which would have a tendency to accept other than the questions.
the answers to which would have a tendency to expose him to criminal charge or to a penalty forfeiture. Here, this 161 is also based on the Article 20, Clause 3. As far as Article 20, Clause 2 is concerned, it is a protection against the double jeopardy. Once a case is tried and once he is acquitted, he cannot be tried again for the same offense. That is as far as these grounds of arrest. They have to disclose the grounds of arrest to the accused on what offense they are arresting, and they have to inform to the accused. That is also taken care of Article 22, Clause 1. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall be denied the right to consult and to be defended by a legal practitioner of his choice. Even legal practitioner is also that's recognized under Article 22, Clause 1. That's why at the time of investigation, accused is entitled to appoint an advocate, and the advocate is also entitled to sit beside the accused. Even that is also recognized in the Nandini Satpathy case also. To safeguard the interest of the accused, Honorable Supreme Court passed several guidelines that have to be followed by the police at the time of the arrest. That is the celebrated cases D.K. Basu versus State of West Bengal 1997 1 SSC 416. 1997 1 SSC 416. D.K. Basu is Honorable Judge who wrote a letter to the Supreme Court to treat it as a public interest litigation because there are so many custodial charges at some places in West Bengal and other parts of India. Then Honorable Supreme Court treated it as plea and passed several directions. Those directions were there in paragraph 35. It's very important because this is the expansion of the fundamental rights by the Honorable Supreme Court, recognizing Article 19, 20, 21, 22. Earlier in A.K. Gopalan case, Article 21 is only once a person was arrested according to law, that is enough. Because there is no interrelation in between the Article 19, 21, 22, like that. But in Maneka Gandhi case, there was a sea change and the perception was changed, and once the liberty was at stake, all these articles are inclusive, they are not exclusive. We can read liberty under Article 21 with the aid of 19, 22, like that, 14. It is stated. These directions, by recognizing the liberty, Honorable Supreme Court treated it as writ petition 35. We therefore consider it appropriate to issue the following requirements to be followed in all cases of arrest or detention till legal provisions are made in the behalf as preventive measures. The police personnel carrying out the arrest and handling the interrogation of the arrestee should bear accurate, visible, and clear identification and name tags with their designations. The particulars of all such police personnel who handle interrogation of the arrestee must be recorded in a register.
that the police officer carrying out arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be tested by at least one witness who may either be a member of the family of the arrestee or respectable person of the local. That's why now it is the duty and the part of the police to inform to the kin and kith of the arrestee, and they have to give the grounds also. So, Honorable Supreme Court, time and again, recognizing the liberty is a valuable right, they have expanded the scope of the uh, criminal law and giving liberties to the accused, even prisoners also. Now we are coming across victim compensation. That is also invention of the Supreme Court with the aid of Article 21. And even solitary confinement is also, Supreme Court said that it is illegal on the threshold of the Article 21. That's why my humble request to all of you is that while we are, even whether we are practicing at martial court, trial court or high court, we should be thorough at least these provisions, because and celebrated judgments, that is D.K. Bose, Sat Patai, Maneka Gandhi, A.K. Gopalan, at least these cases we should be very, very thorough, and Batra, and there are so many cases, but as far as fundamental rights are concerned, we should be very thorough about Jogendra Kumar, who is an advocate. He was retired and habeas corpus was filed. Thereafter, Honorable Supreme Court said that we cannot arrest without giving any reasons. Proper reasons is also very much required. Even power of exercising power is different. Power of having power of arrest is different, and exercising that power is another facet, which is you have to give the reasons for such arrest. You cannot detain an advocate who is practicing for 5 days without disclosing and without informing to the kin and kith. These are the developments, constitutional remedies under the criminal justice system. That's why we have to at least be thorough. The case laws under Article 19, 20, 21, 22, and then at the time of remand, when even we can seek the rejection of that remand when they have not followed the principles laid down by the D.K. Bose. And when they have not completed the investigation within 90 days, we can seek the default bail. And we should be very thorough about these case laws, and by reading these case laws, we can equip with the procedural laws that under CRPC and new BNSS, and new BNSS changes are very little. Those changes already, there are so many writings about these changes in CRPC. Please go through them and then read these judgments. At least these celebrated judgments are the rarest of the rare case, because earlier any murder takes place, death is rule and life is an exception. Now there was steep change after the Bachchan Singh case. The rarest of the rare case theory was that because that case should be distinguished with other cases. Only life is the rule now. Death is an exception. Even now there is a debate whether death penalty can be awarded or not, and under what circumstances. That is the rarest of the rare. How it affects the whole society, and all these things are taken into the consideration
keeping in view of the Article 21 into consideration. This is the chief change in the criminal jurisprudence on the touchstone of the fundamental rights. And we have to be very thorough in all this because now victim compensation is also, it is recognized by the Honorable Supreme Court on the touchstone of the Article 21 only. That's why for procedural aspects are concerned, Article 20 and 22, as far as the safeguards and personal liberty and all other aspects are concerned, Article 21, there are so many judgments. Please read it twice and twice to have these procedural aspects in a perfect manner. Thank you for giving this opportunity.
You have the first day of time. Thanks for the organizers. At first, as an advocate, I can only say, be as a defense counsel. And being a defense counsel, great respect. We have to maintain integrity, honesty, hard work, and regularity. So that's why all these things. Thank you for giving up.
I hope you have taken into consideration of these three persons, the chance of Honorable High Court, not only Honorable High Court Judge Harnath Sharma, and the former public prosecutors of our state, the entire state, Honorable Mr. Nagrik Garu and Goswami. This is the type of education which we want. We will have more time, this type of more discussions in future. Thank you very much. Now, the station, three speakers, including our Honorable Justice Harnath Sharma. Right. Now, I request all the bar council members to come over to the dais to facilitate the free speech.
We now conclude the session, which brought together an esteemed panel of legal minds to discuss the timely and complex topic of the implementation of the new criminal law framework. We extend our heartfelt thanks to our distinguished speakers. Your collective wisdom, practical observations, and candid reflections on legislation, cognizance taking, and a brief of 173 of VNSS and the scope of judicial intervention have truly added value to this training. Thank you once again to all our dignitaries, and we look forward to carrying your insights into practice and discussion ahead. Thank you.
Hello. I request all the members to go out and have a tea. Those who are interested to have a tea for only for 10 minutes. Then validatory session will begin here. Honorable Justice Dr. Variga Siam, and there will be validatory session. Please come and join me after 10 minutes. Thank you. Afterwards, you can go for lunch, not now.
Actually, even I did it because we are partnered with all of the subjects. Scientific would do radiations, which would be in range in like 600. I mean, can you say that is not supposed to? It's not all I'm going to do. We are doing it in 3 days, we've been constantly scanning. See that corner is related corners and everything get excited. That's a radiation. Not even photo, respect the I actually very much enjoyed the session because I have learned a lot. Totally the interesting discharge. And contradicting us but that is right.
We request all participants to take your seats. All the participants outside the hall are requested to assemble inside the seminar hall and take your respective seats. We request all the participants to kindly take your seats. We request all the participants outside the seminar hall to kindly come inside and take your seats as the band committee is about to begin.
అంటే మామూలుగా కనుగొన్న
The valedictory session is about to begin.
డెస్క్ సెట్ చేసుకున్నారా? డెస్క్ సెట్ చేశాను
సరే సరే
నాకు కూడా తీసుకుంటాను.
ఎవరిది
I request everyone to kindly get settled down so we can start with the validity session. We request everybody to kindly be seated as we are starting with the validity session. Good afternoon, everyone. As we wrap up the final round of presentations, it is my pleasure to welcome you all to the validity session of this residential legal profession program. Over the past 3 weeks, we've had the privilege of listening, learning, and reflecting on the evolving landscape of law and justice. When on a chair and experience exchange, we will certainly guide us in our professional journey ahead. As Oliver Wendell Holmes once said, the life of the law has not been logic, it has been an experience. And to this event, we've added both logic and experience to our legal tool. Let us now begin the validity proceedings and take this opportunity to celebrate the success of this meaningful initiative. Now, I request Honorable Sri Nallar Dwarkanath Garu, Chairman, Bar Council of Andhra Pradesh, to come over the dais and around the chair. I request our fellow student to present the sampling to serve as a token of respect. Now, I request Honorable Madhupati Garu, Judge, High Court of Andhra Pradesh, to come over the dais and around the chair. I request Sri Krishna Reddy Garu, member of the Bar Council of Andhra Pradesh, to present the sampling to serve as a token of respect. I request our Honorable Professor Dr. D. Surya Prakash Rao Garu, Honorable Vice Chancellor D.S. Dayas and around the chair. I request Sri Madhavi Garu, member of the Bar Council of Andhra Pradesh, to present the sampling to serve as a token of respect. I request Honorable Sri Krishna Mohan Garu, Vice Chairman, Bar Council of Andhra Pradesh, to come over the dais and around the chair. I request the student to present the sampling to serve as a token of respect. I request Honorable Sri Kanta Ramarao Garu, Senior Advocate and member of the Bar Council of Roti, to come over the dais and around the chair. I request our fellow student to present the sampling to serve as a token of respect. I request Honorable Sri P. Narasimha Garu, member of the Bar Council of AP, to come over the dais and around the chair. I also request our fellow student to present the sampling to serve as a token of respect. I request Honorable Sri Paita Kumar Garu, member of the Bar Council of AP, to come over the dais around the chair. I also request our fellow student to present a sample to sir as a token of respect. I request Honorable Sri K. Ramjogeshwar Rao Garu, member of the Bar Council, to come over the dais and around the chair. I also request our fellow student to present a sample to sir as a token of respect. I request Honorable Shri Mani Reddy Garu, member of the Bar Council of Andhra Pradesh, to come over the dais and around the chair. I request our fellow student to present a sample to sir as a token of respect. I request Honorable Shri B.V. Krishna Reddy Garu, member of the Bar Council, to come over the dais and around the chair. I also request our fellow student to present a sample to sir as a token of respect. I request Honorable Shri N. Ravi Krishna Garu, member of the Bar Council, to come over the dais and around the chair. I also request our fellow student to present a sample to sir as a token of respect. I request Honorable Shri Mani Garu, member of the Bar Council, to come over the dais and around the chair. I request our fellow student to present a sample to ma'am as a token of respect. I request Honorable Shri B. Ravi Garu, member of the Bar Council, to come over the dais and around the chair. I also request a fellow student to present a sample to sir as a token of respect.
అన్న ఎక్కన్నా అవునా వెళ్ళేది ఎప్పుడు అవునా
Thank you, everyone. Now, let us begin with our felicitation program. I request Honorable Shri Natari Dwarkanath Reddy Garu, Chairman, Bar Council of Andhra Pradesh, and Professor Dr. Sumitra Prakash Rao Garu, Vice Chancellor of Damodaran Sanjeevani National Universities, and other dignitaries of the dais to felicitate Honorable Shri Justice Jeevanapati Ravi Garu, Judge of the High Court of Andhra. I request Nalal Dwarkanath Reddy Garu, Chairman, Bar Council of Andhra Pradesh, to preside over the program.
The valedictory session. It's not a barrier. Valedictory session is a barrier, not a barrier between the participants and the judges who give OER and has given presentation on the different subjects. Before we go for lunch, we are very fortunate to hear the son of the soil, Jeevanapati Ravi Garu, the Honorable Judge, who is officers. They will present on a different aspect. We never said whether the Bar Council of Andhra Pradesh or this particular Sanjeevaya University. We are not proposed to say any such, but he will give a different facet of how the advocacy must be. Whether the juniors, seniors, whatever it is. We are very fortunate, sir, you are here. And sometimes we want to
లేదండి మన పిచ్చుకునే కార్యక్రమం పెట్టారు
అలాంటిది ఏం లేదు. మీరు ఈ విశాఖ తీరంలోని ఎన్నో సంవత్సరాలుగా న్యాయవాదిగా ఉండి ఈనాడు రాష్ట్ర ఉన్నత న్యాయస్థానంలోనే ఒక అత్యున్నతమైన న్యాయమూర్తిగా మీరు ఇది శోధించి సాధించుకున్న ఇది చూడండి, వాటి నుండి ఇన్స్పిరేషన్ పొందండి. మీలో ఎంతమంది మన ఆంధ్ర రాష్ట్రానికి కానీ మన దేశానికి జ్యుడిషియరీ కానీ లేకపోతే న్యాయవాదులుగా కానీ ఏ విధంగా మనం సమాజ స్థాపన కోసం లేదు ఈ యొక్క పేద వర్గాల కోసం ఏదో విధంగా ఎలా పట్టుబడాలి అనేది కూడా వారి నుండి మనం నేర్చుకోవాలి. నేను ఒక్క మాట చైర్మన్ బార్ కౌన్సిల్ ఆఫ్ ఆంధ్రప్రదేశ్ ఒకే ఒక మాట చెప్తాను. దయచేసి 10% మీ శక్తియుక్తులు న్యాయవాదులుగా పేదలకు బడుగు వర్గాలకు ఖచ్చితంగా పక్కన పెట్టండి. 90% మీరు ఏ విధంగా మీరు సాధించుకోగలరో సాధించండి. కానీ 10% మాత్రం దయచేసి మీరందరూ కూడా, ఎందుకంటే ఆ 10% భగవంతుని రూపంలో మనకు మన కుటుంబాలకు ఒక శ్రేష్ఠ కలిగిస్తారు. వారు మాట్లాడే ముందు వారు ఏదో తెలుగులో అన్నారు కాబట్టి నేను తెలుగుపోయాను. తెలుగు అతి మధురమైనది. అటువంటి పుణ్యభూమి మన తెలుగు సీమ, ముఖ్యంగా ఆంధ్రప్రదేశ్, తెలంగాణ, పార్ట్ ఆఫ్ కర్ణాటక, పార్ట్ ఆఫ్ తమిళనాడు అండ్ పార్ట్ ఆఫ్ ఒరిస్సా. ఇన్ని రాష్ట్రాల్లో ఈ అద్భుతమైన తెలుగు మాట్లాడే వాళ్ళు కోట్లాది మంది జనాలు. అలాంటి ఈ విశాఖ తీరం నుండి వచ్చిన నవ యువకుడా కాబట్టి రవిగారితో చిరు పరిచయంతో నేను రవిగారు నాకు పెద్ద పరిచయం లేకపోతే చిరు పరిచయం ఉంది. వెరీ నైస్ సార్, very nice to see you here, sir, because you are the son of the soil, and every member of the here is eager to hear your speech. Thank you.
వ్యాలిడిటీ ఫంక్షన్కి రండి, అందరూ ఎలా పెట్టారో కనుక్కోండి, థ్యాంక్స్ చెప్పండి అని తీసి కూర్చోబెట్టి ప్రెసిడెంట్ గారు, చైర్మన్ గారు వాళ్ళు లెక్చర్ ఇవ్వండి, యాటిట్యూడ్గా ఎలా ఉండాలో చెప్పండి, పెట్టుకోరండి. ఇక్కడ భోజనం టైం అయింది, ఇట్ ఈస్ నౌ లంచ్ టైం. సో ఇన్ బిట్వీన్ లంచ్ అండ్ యూ ఐఎమ్ మేకింగ్ ది స్టాండ్ అంటే క్లాస్ చెప్పమంటారు. ఇంత భోజనం చేయడం తప్పే కదా. బట్ నాకు చాలా ఇష్టం. యంగ్స్టర్స్కి గైడ్ చేయాలి. నేను ఏదైనా నేర్చుకున్నాను అని ఒక చిన్న భావన నాలో ఉంటే అది చెప్పాలి అని నాకు మొదటి నుంచి ఇష్టం. సో I don't know whether I should say good morning or good afternoon. I say hello everyone. And making me to stand before legal luminaries and youngsters who are hungry and ask me to talk is a little difficult task. But whatever, please bear me for a moment. This lecture, whatever the program they have arranged last 2 days, is very excellent program. In our days, I don't remember that I went to any such programs. There is nothing like that. If I'm not wrong. And we are so fortunate to have the seminars. With my little knowledge, these seminars are something like a practical, theoretical knowledge. Coming to practical, it's very difficult. Practical advocacy is more important. In interpretation of law, each provision, whatever provision you read, again you read next time, it will be new. My feeling. So, during the course of your practice, you will definitely improve your skills, your advocacy, and knowledge. Apart from this theoretical and practical knowledge, the role of an advocate in the society is very important. In the olden times, I used to hear, because I'm fortunate to be a second generation of lawyer, if some claimant comes to an advocate office with some problem, advocates used to settle the issue outside the purview of the court, maximum extent. They never drive them to the courts in a casual manner. If at all they have to issue a legal notice, they used to put a lot of effort for giving a legal notice. Legal notice is the foundation for the claimant's case. If you issue a legal notice in a casual manner, the fate of the claimant, you can see, imagine. సో ఎర్లియర్ టైమ్స్లో నోటీస్ ఇవ్వాలంటే చాలా ఆలోచించి డిస్కస్ చేసి లా చదివి that case, that legal notice will stand till it reaches the Supreme Court. Foundation. ఇప్పుడు left, right, center notices are being legal notice are giving very in a casual manner. రావడం తర్వాత 2 లైన్లో 2 పేరాలో రాసి నోటీస్ ఇచ్చడం, ఇంకా అక్కడి నుంచి దాన్ని ఎలాగా నిర్మించుకుంటూ రావాలి అన్నది తలపడుకోవడం. అడ్వకేట్ అవ్వాలి, నేను అడ్వకేట్ అయిన వెంటనే అసలు ఈ ప్రొఫెషనల్ అవుతామని నాకు ఉద్దేశం లేదండి. 3 days చదువుకోవాలంటే ఎక్కడ ఏదో లా చేశాను, ప్రొఫెషనల్గా వచ్చాను. The day one, my father told me about integrity, honesty, dedication, hard work, and sense. These qualities are very important. Every day you have to visualize and prepare. Dedication, but friends, honestly, I am telling you, these are the most important elements in the life. No doubt about it. ప్రాక్టీస్లోకి వచ్చిన వెంటనే మనం సెకండ్ జనరేషన్, ఫస్ట్ జనరేషన్ లాయర్స్ అంటే వెరీ డిఫికల్ట్ టు సర్వైవ్ ఇన్ దిస్ ప్రొఫెషన్. సెకండ్ జనరేషన్ కేక్ వాక్, చక్కటి నాటకాలు, కేసు సంపాదించడం, ఉన్నాయి, ముందర బుక్స్ ఉన్నాయి, టేబుల్ ఉంది, అందరూ ఉన్నారు. కళ్ళు మూసుకుని తెలిసరికి మనం ఈ ప్రిన్సిపల్స్ ఫాలో అవ్వకుండా క్యాజువల్ గా ప్రాక్టీస్ తీసుకుంటే కళ్ళు మూసి తెలిసరికి అక్కడ బుక్స్ ఉన్నాయి. అదే ఫస్ట్ జనరేషన్ అయినా సరే ఈ ప్రిన్సిపల్స్ ఏవైతే చెప్పారో అవి కానీ అడాప్ట్ చేసుకుంటే యూ విల్ బికమ్ ఎ సక్సెస్ఫుల్ లాయర్. According to me, success means standing in the society as a role model. That is success. Not making money or not taking number of cases. కొడుకు అన్నవాడు ఉంటే ఎలా ఉండాలి, లాయర్ ఉన్నవాడు అంటే ఎలా ఉండాలి. సరే నేను లాయర్ అయిపోయిన కోర్టు చేసుకున్నాను, బ్యాంక్ సర్వీసుకున్నాను, కోర్టు పెట్టుకున్నాను, వచ్చేస్తాను. లాయర్ అంటే అని అనుకుని సంథింగ్ దట్ మస్ట్ బి అని. What is the role of advocate role in the society? There is a judgment of Supreme Court. Next time I will send all the presidents of the Bar Association to circulate the youngsters. క్లయింట్ తో ఎలా ఉండాలి, బార్ మెంబర్స్ తో ఎలా ఉండాలి, అదర్ సైడ్ అడ్వకేట్ ఎలా ఉండాలి, బెంచ్ తో రిలేషన్షిప్ బెంచ్ అండ్ బార్ ఎలా ఉండాలి, క్లయింట్ తో ఎలా ఉండాలి, అదర్ సైడ్ అపోనెంట్ క్లయింట్ తో ఎలా ఉండాలి అన్నది రాసింది. చాలా బాగా రాశారు. దో ఇట్ ఇస్ వెరీ డిఫికల్ట్ to adopt those principles laid down in the Supreme Court judgment, but if you practice, nothing difficult. నేను కూడా బార్లో మెంబర్ని కదా, కృష్ణారెడ్డి గారికి కృష్ణమోహన్ గారికి నేను ఎందుకు రాయించేది ఆయన కాబట్టి నేను బాగా అనుకునే నేను అనుకునేవాను. ఐఎమ్ ఆల్సో అడ్వకేట్ బికాస్ an advocate. That is wrong. Tomorrow somebody wants to elevate your character, elevate your life by giving some post or whatever. The person will definitely ask some of the bar members, వాళ్ళు తెలిసిన వాళ్ళు, పలానా రవి చౌదరి ఉన్నాడు ఎలా ఉంటాడండి, నేను వీళ్ళ ఖాతరు చేయకుండా నేను ఉంటే ఖాతరు చేయలేదు, గోతులు ఎక్కువ ఎవరు పట్టించుకోడు. Finish. When you respect each and every member in the bar and a judicial officer in the conducting case, even enemy also will respect you. Shatru kuda jealousy unnadu kuda cheppalante baada anpinchali. That is the way you have to live in life, whether it is an advocate or whatever. Our life revolves between three persons, I believe. Parents and Guru. Matrudev, Pitrudev, Acharyadev. And written out about and born over after. The persons who respect all these characters in their life, their life will be very happy in the future. So according to me, advocate should be a role model of society. When advocate, right, everybody work is a doctor, any professional or citizen of this country. Advocate exchange ఇప్పుడు ఎంతమంది పెడతారండి అడ్వకేట్ అంటే, బికాస్ వీఆర్ స్పాయిలింగ్ టైం. ఒక సిగ్నల్ బ్రేక్ గా రావడం, పోలీసు వాడు వచ్చేస్తా నేను అడ్వకేట్, రాంగ్ పార్కింగ్ లో కార్ తీసుకొచ్చి పెట్టడం కోర్ట్ కాంప్లెక్స్ లో నేను అడ్వకేట్. అడ్వకేట్ అంటే కాదు కదా. When we don't follow law, who will respect us? Nobody will respect us. We are law protectors. We have more responsibility than other citizens in the society. So advocate role is very difficult, and it is all within us how to gain respect in the society. Juniors, seniors కి ఇవ్వాల్సిన రెస్పెక్ట్ కోర్టులో ఇవ్వడం, వారు ఒకరిని గురువుగా పెట్టుకోవడం, జూనియర్షిప్ చేయడం, వారు చెప్పిన కేసుని రీసెర్చ్ చేయడం. ఇప్పుడు అంతా ఏరాలో ఇక్కడ పూర్వం రీడ్ బుక్స్, నౌ వన్ బటన్ జడ్జ్మెంట్ ఇస్ కమింగ్. సో నౌ ఇట్స్ వెరీ ఈజీ. సో ఇఫ్ యూ మెయిన్ గురువు పొద్దున ఆఫీస్ 9 అంటే 9:15 రావడం కాదు, 5 minutes before రావాలి. Then you gain confidence in the mind of your seniors. Totally respect. My bar members respect ఇవ్వడంలో నేను అడ్వాంటేజ్ ఎలా పొందానంటే, హౌసన్ గారు కోర్టులో పొద్దున్న 10:50 నుంచి 10:30 నుంచి 5 వరకు 10:50 కోర్టులో కూర్చుంటే సీనియర్స్ కొంతమంది చేయలేని కేసులు, వీడు రోజు రెగ్యులర్ కోర్టుకు వస్తున్నాడు, వీడు చాలా మర్యాదగా ఉన్నాడు, కోర్టులో బాగున్నాడు, అలా కేసులు కూడా వస్తున్నాయన్నారు. సో ఐ గాట్ కేసెస్ త్రూ వేరియస్ అదర్ ఫ్రెండ్స్ అడ్వకేట్స్. There are lot of advantage in those things. So hard work is very important. How honest you are playing, how honest your society is very important. It plays a vital role, and no control is required. You can lay your own path. Everybody will be after you. If you think that I gain knowledge, if I think I gain knowledge, I'm a fool. And practice చేసినప్పుడు ఏ బ్రాంచ్ ఆఫ్ లా నువ్వు అడిగారు which branch of law you are practicing. I used to say that I'm jack of all trades, master of none. So we Tala, you have an advantageous situation in life. You have a lot of softwares and good seniors, good conference, bar council is conducting very good conferences like this. So you should take all these advantages of Uttama Velitama. And one thing honestly I'm telling you, this profession is very difficult if you are not meticulous and follow principles. If you follow principles, this profession is very easy to take work. No doubt about it. So, ఇంతకన్నా చెప్పేటుంటే మీరు నన్ను చాలా మంది నేను పెన్షన్ ఉన్నప్పుడు యంగ్స్టర్స్ టెక్స్టైల్స్ వచ్చినాడు ఒకడు, స్కూల్కి వచ్చినాడు ఒకడు, షర్ట్ మ్యాచ్ అవుతున్నాడు ఒకడు, జీన్స్ ప్యాంట్ వేసుకొచ్చినాడు ఒకడు. ఏమా సో బాగా అనిపిస్తుంది కదండి. We are surviving in this profession. We are nothing but we are sitting on the tree and cutting our branch. మనం పడిపోతాం. పాపం తెలియదండి. ఇట్స్ నాట్ దట్ చెప్పేవాళ్ళు లేక సీనియర్ చెప్తే ఎందుకు గొడవ ఎందుకు మనకి కొండలో పోతాడో మనకి ఎందుకు ఈ పని కూడా పోతుంది మనకి అనుకున్నారు. ఇట్స్ అ ఫ్యాక్ట్. నేను చెప్తా తిప్పుకుంటారు, బయట తిప్పుకుంటారు, మనుషులు తిప్పుకుంటారు, మనం చెప్తారు కదా. So that advantage is this one. Basically, I always tell them, if you don't come proper dress code, I will not entertain you to argue the case. You don't come with a bundle, I will not hear you. Why that question is a bundle chetra unali. Basic fact. Oka point in the case lo fear complex చాలా మంది ఉంటున్నాయి పాపం. ఆ fear ని పోగొట్టాలి మనసు. ఆ కర్తన్, ఆ fear కర్తన్ అనేది తీసేస్తే అందరూ జనరేషన్ అడ్వకేట్స్ జస్ట్ సింపుల్ వాళ్ళ ఒక లైట్ ఫోకస్ ఉంటే దే బికమ్ వెరీ గుడ్ సక్సెస్ఫుల్ లాయర్స్ విత్ ఇన్ షార్ట్ టైం. నేను 20 ఏళ్ళు కష్టపడిన దాంట్లో ఒక 5 ఏళ్ళలో 5 ఏళ్ళు కూడా అవసరం లేదు, దే బికమ్ వెరీ గుడ్ సక్సెస్ఫుల్ లాయర్. సో దీస్ రెస్పెక్ట్ చాలా ఇంపార్టెంట్ because we are respecting our own system, our own institution. So with this little thing, I close my session as a role as an advocate in the society. And ఇంట్లో చాలా మంది వినే ఉంటారు, వాళ్ళ సోదరులు ఉంటారు, ఎక్కడ భోజనం మీరే తక్కువచ్చు, నా చెప్పవలసిన బాధ్యత నేను చెప్పాను. ఇప్పుడు మదర్ ఉంటారు, అమ్మ సోదరులు చెప్తున్నారు, చిన్నప్పటి నుంచి భోజనం చెప్తుంది. మన ఎంత వయసు అమలుతుంది ఏంటన్నా సోదరు చెప్పాలనుకున్నారు నేను కూడా అనుకున్నాను. అది కలిసి చెప్తాం. దానివల్ల మనకు వచ్చేది ఎసిడిటీ, షుగరు, డాక్టర్ దగ్గర వెళ్తాం. కాబట్టి మీరు సరిగ్గా డైట్ తినలేదు, సరిగ్గా టైం తినలేదు, టైం తింటే ఉండేది కాదు కదండి, మీరు తినలేదు. సో ఈ మాత్రలు వేసుకోండి, ఈ టైంలో భోజనం చేయండి, ఈ టైంలో పడుకోవాలని అనుకున్నాం. అంత ముందర తల్లి చెప్పేది కూడా ఇప్పుడు డాక్టర్ చెప్తారు హెల్త్ విషయం వచ్చేది. సో ఏ సీనియర్స్ చెప్పినా, ఏ గురువు చెప్పినా అది మన మంచి గురించి చెప్తారు తప్ప మన చెడుగా పట్టే దాని గురించి కాదు. మనం అందరూ దాన్ని విశ్లేషించుకోవాలి, దాన్ని ఫాలో అవ్వండి, మన నించుకోవాలి గౌరవం. సో హ్యావ్ ఎ మోరల్ రెస్పాన్సిబిలిటీ ఆన్ ది సొసైటీ టు be careful as an advocate. Advocate role is very difficult, and పేదవాళ్ళు కూడా మీకు చేసిన సహాయం చేసి వాళ్ళ ముందర కూడా వాళ్ళకి సహాయం చేస్తూ వాళ్ళు కూడా లా ఏంటుంది దాన్ని వాళ్ళు అలాగే దాన్ని వినియోగించుకోగలరు ఇలాంటివి మీరు చెప్పగలిస్తే చాలా బాగుంటుంది. Now with regard to this validity, firstly I should thank Dr. Ramaru garu for inviting me as chief guest. I also should thank Sri Surya Prakash garu, the Vice Chancellor of this university, for providing this hall and infrastructure and one main thing and making this event a grand success. I thank you, Mr. Surya Prakash, for my support. And I wish you should always support this manner. And I also thank the Bar Council for arranging such a lovely event and dubbing it as residential legal refreshing program. And I also appreciate your presence in this occasion. చాలా ఓపికగా వచ్చి కూర్చొని విని పార్టిసిపేట్ చేస్తూ మీకున్న డౌట్లు చెప్తూ అడుగుతూ I also should thank you and all the legal resources persons who have addressed the gathering. I also thank them from bottom of my heart for sparing their valuable time and addressing the gathering on the subjects, various subjects. 11th, now time unte 11th, 12th kuda 12th and 13th also would have been here. Nenu kuda nestunnanu and I heard the lecture of Arvind Sharma. ఆయన డైరెక్టర్ గా ఇందులో వేసారని కూడా ఇంజెక్షన్స్ సబ్జెక్ట్ సార్ very honored to hear your subject, and I also thank all the other persons who have addressed the gathering. Mostly I say English, but more importantly, it has reminded us that learning law is an ongoing journey. The legal landscape evolves rapidly, and so must be. The courtroom is not just a battleground, but a dynamic arena of constant change. And the advocate must adapt to meet these challenges. I extend my deepest gratitude to all our professors, mentors, and advisors for their guidance and support. I also want to express my sincere appreciation to all the participants for their spirited engagement and dedication in making this program truly meaningful. And you all continue to thrive in your legal endeavors. Thank you very much.
న్యాయవాద మిత్రులారా, ఇప్పటి వరకు జరిగిన ఈ సమావేశంలో ఈ యొక్క ముగింపు సమావేశానికి ముఖ్య అతిథిగా విచ్చేసిన శివపాటి రవి గారు చెప్పిండే ఈ ఉపన్యాసంలోని సారాంశాన్ని మొట్టమొదటి సారాంశం ఏంటి? తల్లిదండ్రులకు గౌరవించాలి. నెక్స్ట్ తల్లిదండ్రులను గౌరవించండి, గురువులు గౌరవించండి, తోటి న్యాయవాదులకు ఎలా మీరు ప్రవర్తించాలో కోర్టుల్లో ఆలోచించుకోండి. అదేవిధంగా జడ్జీలకు మీకు ఉన్న ఏమైనా అంతరాలు ఉంటే ఆ అంతరాలకు న్యాయవాద వృత్తిని కొనసాగించండి. క్రమశిక్షణ. నేను ఈనాడు ఈ ఉన్నతానికి వచ్చానంటే ఈ క్రమశిక్షణ అది సినాప్ ఇంటర్ప్రిటేషన్ అర్థాన్ని గ్రహించాలి. ఏ ఏ ఏ భక్త కానీ అన్ని ఆయన హృదయంలోని అన్ని విషయాలు చెప్పడు. ఆ హృదయంలోని భావనలు తెలుగులో అయితే చంద్రబాబు నాలి, కన్నడంలో అయితే చంద్రగేడి సార్, తమిళలో అయితే ఇంగ్లీష్ లో అయితే ఇట్స్ వెరీ ఇన్ఫర్మేటివ్. We are very thankful to you, sir, for this valedictory address. Thank you very much. Now, presentation to the chief guests and other members, our council and also our friend, yes, the vice chancellor of this great university, university, and not forget. I can't forget. I hope so you will forget. Oh. Yeah. That is we had two orientation programs. First program. We had the first program here, the second program is also first. Sir, what is the difference in seminar at this particular thing? In many of the seminars I observed, half of the members are the local persons, let it be Tirupati or Vishaka or any persons. 30 or 40 or 50 attendants will come. Others only are students. This is the unique meeting where there is no non-student. Entire community from the entire class of us. We are all members of the Bar Council and the Vice Chancellor of this university. Very happy to see all of you, to have acquaintance with all of you. I hope so. Yesterday I told you that you have an acquaintance with the other friends. How that will be helpful to you in your life. This is the time when you have the friendship with the other person. Thank you very much. Now, extensions to our chief guest.
Thank you so much, sir, for those enlightening words. I request Honorable Sri Nalala Chairman, Bar Council of Andhra Pradesh, and Professor Dr. Sri Prakash Rao, Vice Chancellor of Tamil National University, and other dignitaries of the dais, to felicitate Honorable Sri Justice Chirulapati Ravi Garu, Judge of the High Court of Andhra Now, I request our Honorable Vice Chancellor, Professor Dr. Sri Prakash Rao, to felicitate Sri Nalala Reddy Garu, Chairman of the Bar Council.
All the participants are requested to wait for 5 minutes. We will finish all the book. Please take your seats.
I request our Honorable Vice Chancellor, sir, to felicitate Sri Sirapalpu Krishna Mohan Garu, Vice Chair of the Bar Council of Andhra Pradesh.
I request Honorable Chairman and other members to felicitate the Vice Chancellor, this BSML. I request the chairman of the members to restart. Please restart. University come on to that.
Now, I request our Honorable Vice Chancellor, sir, Professor Dr. D. Surya Prakash Rao Garu, and other dignitaries on the dais to felicitate Sri Kanta Rama Rao Garu, Senior Member and Advocate of the Bar House. Thank you, sir. I request our Honorable Vice Chancellor, sir, and other dignitaries on the dais to felicitate Sri P. Narasimha Rao Garu, Member of the Bar Council of Andhra Pradesh. Thank you, sir. I request our Honorable Vice Chancellor, sir, along with other dignitaries on the dais, to felicitate Sri Paita Arun Kumar Garu, Member of the Bar Council of Andhra Pradesh. I request our Honorable Vice Chancellor, sir, along with other dignitaries on the dais, to felicitate Sri Ram Yogeshwar Rao Garu, Member of the Bar Council of Andhra Pradesh. of the Bar Council of Andhra Pradesh. Now, the felicitation of Sri B.V. Krishna Reddy Garu, member of the Bar Council of Andhra Pradesh. Now, the felicitation of Sri Rolla Madhavi Garu, member of the Bar Council of Andhra Pradesh.
అదే నేను అంటాను రెండు వాళ్ళకి లంచ్ కెళ్ళి రెడీ వచ్చినప్పుడు
రాయాల్సిన
యాభై రాసాము మేడం 30 దాకా రాసాము రాయాల్సి వస్తుంది డైలీ పెట్టి రాపిస్తే 30 మంది ఉన్నారు మరి వీళ్ళలో ఇంకెంతమంది వస్తారు ఇది కూడా 30 రాపించాం
The felicitation of P. Ravi Kubera Garu, member of the Bar Council of Andhra Pradesh.
ఏం చేస్తాను
Now, the felicitation of M.K. Srinivas Garu, President of the Bar Association. Thank you for all the dignitaries. Now we request
Good afternoon to all of you. The day begins, our program begins from 2 a.m. now. We have to begin. One day it will be over. I thank the Chimalapati, Justice Chimalapati Ravi Garu for gracing this occasion and delivering his address. And whatever he says, in fact, his father, Sri Ram Murthy, who practiced for considerable time here, more than 50 years, I think, and Visakhapatnam is a role model. What he has said is, he can emulate by seeing at his lifestyle. So, one of the factors is that the moment he became Judge of the High Court, his father stopped using practice, which is clear to him. To have a discipline in the profession is one of the indications. We thanks Sri V. Surya Prakash Rao Garu on behalf of the Bar Council, the Honorable Vice Chancellor of this university, and in fact, the Honorable Vice Chancellor, we told you, promised you that all the properties including the fruit bearing trees and fruits are intact. In the same stage where we enter this campus, so more than 400 people are here, and everything is become possible because of the cooperation of the Honorable Vice Chancellor and Registrar. Registrar in fact was personally supervised every arrangement, and but for their cooperation it would not have been this much of success. We, from the bottom of our heart, we thank the academic staff, administrative staff, and the existing staff who made our stay here very comfortable, and also a canteen contractor. Only one disadvantage is every one of us weight was increased. Very difficult to deal with that. And also thank to the Ramjogeshwara and the yoga teachers who made us our life comfortable by rendering these yoga teaching. And regarding the 3 days programs, we have had the benefit of, it was inaugurated by last Justice Raghunath Rao garu, and thereafter in the first session, Sri C. Venkateswara garu delivered a wonderful lecture. Thereafter Justice Sitaram Murthy garu, then BVL and Justice BVL and Chakravarti garu, the NY Mr. Rishwik, who enlightened us on AI, and Justice L. Nageswara garu, in spite of busy schedule, coming here, rendering a wonderful lecture to us. Justice C. V. Naganchandra garu and Justice Durga Prasad garu, Justice Sri Swacharao garu, the retired district judge, and Bhairapanai Naresh garu, the senior advocate, and Chennam Chetty Raju garu, the honorable district judge Visakhapatnam, and Justice Hari Harinada Sarnagaru, a concluding session. He made a wonderful presentation using all his experience as a director of judicial academy. And we thank everybody and who helped us to make this program. I personally thank the Honorable Chairman and other members in giving me full liberty to organize this program. And I thank everyone, especially the participants, for keeping these 3 days peaceful, happy. And I also thank the singers who presented a melodious songs. Of course, made us to participate in the cultural program. These 2 nights during our stay. And there was an announcement. There will be a bus facility from 4 to 6 p.m. from campus to the main center, that is the, I think, statue, NTR statue, in Samara. After lunch, you can pack up and plan to depart between these 2 times, from 4 to 6, to have a conveyance to reach your destinations. Thank you, one and all, who made this program. Now, Janaganamana, please. Participation certificates are there in the door. You have mentioned, collect those certificates and you have use the bus facility and reach your destination safely. I would also say special thanks to all those participants who participated in the director section, and especially Justice Kiran and who we are not only the smart, thank you, Ananda, for making, because in witness of the things, now we have one personality among us, and I publicly apologize to him. Even there are some lapses is having that magnanimity. Now we give the grace of this occasion. And thank you, sir. Thank you from the bottom of our heart. With this, this conclusion, this complete program comes to an end with Jana Data Bana.